the top law enforcement officer in the state of Texas, impeached.
Republicans and Democrats in the Texas House of Representatives overwhelmingly adopting 20 articles for misconduct.
It's 10 times worse than it's been voted.
Ken Paxton maintaining his innocence, calling it all politics.
And they are showcasing their absolute contempt for the electoral process.
Now all eyes are on the Texas Senate for the first impeachment trial of a Texas Attorney General.
Everyone will do their job to the utmost in fairness.
KVUE special coverage of the impeachment trial of Texas Attorney General Ken Paxton starts now.
Well, good morning. We thank you for joining us for this KVUE Plus special coverage of the impeachment trial of suspended Texas Attorney General Ken Paxton. You can see a live look inside the chamber now.
And here we are on day 7, about to begin a new round of testimony as the House impeachment managers continue putting on their case.
Austin Osborne, the Sergeant at Arms of the Senate, who's acting as the bailiff in this case, is going to retrieve the jury now. You can see the senators walking in for, as Tony said, their 7th day in this, in this trial.
Who's feeling it?
Yeah. I think, Tony Busby at one point last night while he was cross-examining the last witness said, will you just answer my question so we can all go home?
Yeah, exactly.
And that certainly, I think, is the feeling as we're going into this, the second week, the 7th day. And there she is, State Senator Angela Paxton, blowing kisses.
Which she has done several. She's waved. I don't know that I've seen her blow a kiss, but she is certainly cognizant of the people in the Senate chamber, those spectators there.
Yeah, our photographer on the ground said she did blow a kiss at the crowd the first day, but there we all just saw it. Her,
Would our senator come up to lead us in prayer?
Quite jovial. Every day the Senate starts with a prayer, and that is custom and tradition for the Texas Senate, and this is no exception. So let us listen in now.
Heavenly Father, we come to you this morning, thankful to know the Holy Spirit surrounds us, for where 2 or more are gathered in your honor, you are present in our midst. Time and time again, you continue to love us as your imperfect children. Lord, I ask you to forgive us our failures and sins, and through your Son, we are truly forgiven and washed clean in your kingdom. Lord, we thank you for you, God alone, are the way, the truth, and the life everlasting. Father, we come to you this morning with needing hearts. May we not dismiss the gravity of our actions we have here today, and may we seek your wisdom, discernment, patience, and just understanding. Father, we ask you to clear and calm our minds to be ever present here, so we may have pure intent in our decision making. Amen.
Thank you, Senator. You all may be seated. To both parties, there was the thought that we may have to meet this morning. Did you all work out whatever you all were going to work out on exhibits last night?
Your Honor, we're still working through some of those issues. We didn't get exhibits from them until this morning, and so we still have some questions that we're working through. I think what we've discussed is that we can address those at the first break, or at least that's what we're working towards.
All right, thank you. Members, the time clock, the House has 5 hours, 17 minutes, 2 seconds remaining, with all time that we gave back yesterday added already into that. Respondent has 9 hours, 57 minutes, and 27 seconds remaining. I want to remind the jurors that no phones are to be used on the floor, even during breaks. There may have been a little misunderstanding of that. If you're on a break and you need to make a call, you need to leave the chamber. No phones should be used behind the brass rail or in the court setting during the time we're in session. Mr. Guerin, are you up first this morning?
No, Your Honor, Mr. Donnelly.
Okay, Mr. Donnelly. All right.
Mr. President, we call Laura Olson to this.
Laura Olson, the bailiff will bring Laura Olson. Yes, hold on, bailiff, 1 second. Please come up.
Laura to the list and talk
through.
Okay, and this is certainly the testimony
a huge moment.
So many of us have been waiting for. Laura Olson is the woman whom Ken Paxton was having an extramarital affair with. And up until this point, we have heard testimony on all of the articles of impeachment except those related to the bribery charges. And this is the bribery that the House managers say Ken Paxton was bribed by Nate Paul in exchange for helping him with his case, that Nate Paul hired Laura Olson in Austin so that she could be closer to Paxton, and that Nate Paul also paid for a renovation to the Paxton's home. So certainly, I think this is. This is a huge moment, Ashley, in this trial. Not only for the more salacious aspect of it, but to be clear, the reason Laura Olson's testimony is significant is because of what we were just saying. The question here is, what benefit did Ken Paxton allegedly receive for his aid to Nate Paul? And one of those alleged benefits was employment for his mistress, Laura Olson. And so what we anticipate she will testify to is everything about her knowledge in terms of getting a job at World Class Holdings, Nate Paul's company, how that all came about, what discussions were had. We're looking at Angela Paxton right now smiling, which if we thought that the testimony of Missy Carey, who was Paxton's former chief of staff, testifying about the affair was uncomfortable, we can certainly just imagine what it is going to be like when she is face to face looking at her husband's mistress on the stand, particularly, during Missy Carey's testimony, Angela Paxton remained sort of straight-faced, but looking squarely at her, taking notes. If you've been on social media, the picture I think most popularly going around is Angela Paxton staring at her wedding ring at one point during some of the testimony. And so this certainly, I think, will not only
a pivotal moment to say the least, and not just, as we've said, for the optics, but because of the facts, her perspective, her own testimony that she will likely provide in this historic impeachment trial, a seminal moment we're approaching here.
And not only that, Tony, when you think about the claims that Paxton misused his office to carry out this affair, that his staff and his bodyguards essentially were having to work odd hours, work late hours, things that they were complaining to the chief of staff about. But you can see a lot of talk happening at the dais between the attorneys. I would imagine trying to clarify what they're going to cannot ask
her. Yeah, and Ashley, to be clear, with regard to Angela Paxton, clearly and certainly this is not as though she's first hearing about this affair for the first time during this trial. We know through previous testimony, including, as you mentioned, Missy Carey, that Angela Paxton was aware of this affair going back to 2018, 2019, that there was a meeting in which Angela Paxton attended with Ken Paxton's high-level staff, including Carey, which he acknowledged the affair, apologized for the affair. Missy Carey describing this intimate moment inside that meeting room when she hugged Angela Paxton, told her that she was sorry that this was happening to her and had happened to her. But we also know, as part of that testimony, that the affair continued.
Right, and we don't know how much communication, Angela Paxton had with Laura Olson. Now, Laura Olson, a former aide for State Senator Donna Campbell, who she was a staffer for her, who is a judge sitting here. So there also has to be some level of discomfort there, for her. And she's well known within, the GOP realm and GOP circles.
There are pictures of her with the presiding officer of this trial, with Dan Patrick.
This is, so the significance of her taking the stand, and not just taking the stand, but taking that oath to tell the whole truth. certainly before this body.
And it'll be interesting to see how much whole truth we actually get to.
Right.
I mean,
if she will
you
be
can
standoffish or.
And one of the things too, Ashley, that Attorney James Wood, who joined us yesterday, pointed out, and that is, it could be provide a disadvantage for House prosecutors to possibly go at the more sultry details of this relationship.
Sure.
But they also risk potentially turning off some of the Senate jurors if they go too far with their line of questioning. So I think that one of the things that we will likely see is them really focus on the facts of her employment.
Let's listen to the rules we're going to hear right now.
Witnesses must be given 24-hour notice, and Ms. Olson was put on the list at 3:53 yesterday, so she would not be eligible until 3:53 today. And the same thing applies. Either side can put on a witness on their list up till noon that they can call in the morning the next morning, but after that, it's when they put them on the list. The defense has some on the list for later this afternoon, for example, that they can't call up until then if they choose to. So with that, Mr. DeGuerin?
Yes, Your Honor. Ms. Epley will call Ray Chester as the next witness.
Bailiff will bring in Ray Chester.
Okay, so that is a bit of a turn
yeah.
in events there that, as you heard, Laura Olson was just told yesterday at 3:53.
Remember, the reason for that was so each side can prepare for a witness in time when they appear.
At 3:53 p.m. that she was going to need to appear to testify, and so we are moving on to a different witness.
And Ray Chester is associated with the Midday Foundation, Ashley, so he will likely provide testimony about efforts to assist Nate Paul, alleged efforts to assist Nate Paul in his ongoing litigation with the Midday Foundation, which House managers and prosecutors contend provided an advantage to Nate Paul, but placed the Midday Foundation, that nonprofit, that large nonprofit, at a disadvantage in the litigation.
Well, and now what's interesting is the prosecution only has 5 hours left compared to the defense's nearly almost 10 hours, and so nearly double the time to question these witnesses. We know they want to question Laura Olson. They weren't apparently saving her for last. And to do that and leave enough time to cross-examine. So it will be interesting to see how long they take.
Thank you, Mr. President.
Let's go ahead and listen in.
Please introduce yourself to the ladies and gentlemen of the Senate.
My name is Ray Chester.
And Mr. Chester, what do you do for a living?
I'm an attorney in private practice. I'm a partner at the Austin law firm of McGinnis Lockridge.
Are you the same Ray Chester that we might have heard connected to the Midday Foundation and issues with the Office of the Attorney General in 2020?
Yes, I've represented the Midday Foundation since 2016.
And where is the Midday Foundation located?
Currently, they're mainly located in Brownsville.
Okay. What does the Midday Foundation do?
Currently, well, they were started by Roy Midday, who grew up dirt poor in Brownsville, and self-made man. It's actually a family foundation. It's not a public charity. They don't accept public donations. And for many years, they mainly provided scholarships to needy students. And in recent years, they've shifted their focus back to Roy's hometown of Brownsville, and they've developed the Midday Cultural District in Brownsville.
Who runs the Midday Foundation now?
Roy's grandson, R.J. Midday. R.J. was born with cerebral palsy. You may know him as Walt Jr. from the TV show Breaking Bad. He's an accomplished actor. More importantly, he's an international spokesperson on disabilities and the rights of the disabled. He's worked with the United Nations, the State Department, United Cerebral Palsy Foundation, and he gives motivational speeches to students on anti-bullying and overcoming disabilities.
Thank you, sir. The Mitty Foundation has been disparaged somewhat over the last couple of days in regards to prior management. How long ago were those issues?
They were in the 2000s, and Mitty Foundation received a clean bill of health in 2011 and has been squeaky clean ever since.
Has management changed since that date?
Yes, the problems were Roy's son and RJ's dad.
Let me interrupt you, Mr. Chester. I'm sorry. I'm on a time clock, and I expect they might ask you those questions.
Okay.
What I'm trying to determine is there any rational basis, given the change of management and the time frame, for the Office of the Attorney General to use those issues to justify intervention?
Objection.
None.
Objection, Mr. President, calls for speculation and improper opinion by this witness without a predicate.
Overruled.
You may answer the question.
None whatsoever.
Let me turn your attention quickly then to the settlement from World Class Holdings that we've heard in detail. What was that settlement value?
We settled in July of 2019 for $10.5 million.
After the breach of contract, what did the Office of the Attorney General push you to settle for at mediation?
Objection, hearsay.
Sustained.
Your Honor, if I may, he was present at the interactions. It's an operative fact, and it's already in the record. There is no harm from the hearsay.
I ruled.
Okay.
Mr. President, to be clear, because this may come up again, all these conversations would be privileged under Texas Rule of Evidence 408 as settlement discussions as well.
Mr. Chester, would you or the Mitty Foundation have an opinion as to whether or not you're interested in waiving that privilege?
We are willing to waive that privilege.
In that case, what would the result have been of you agreeing to settle at the mediation with Darren McCarty?
Objection calls for speculation and hearsay.
Overruled.
We would have received pennies on the dollar.
Do you have an approximate value, or do you recall the number that you were pushed to accept?
The only firm offer was...
Objection, Mr. President. Hearsay.
Your Honor, it's an admission by party opponent. It was an action on behalf of Ken Paxton by the Office of the Attorney General, and it's integral to the facts of this case.
And there is no evidence of that. None.
The evidence comes from the witness, as it always does in trial.
Stop for a moment. Overruled.
Let me do it this way, since relevant facts are already in the record for the Senate to consider. What is the end result, considering that you were able to proceed with litigation?
We are poised to wrap up the litigation. The partnership properties are under contract. Mitty stands to receive approximately $23 million.
And when you say stands to receive, is that up to whether or not Nate Paul or World Class Holdings chooses to pay you?
No, fortunately, we're not depending on that because that would be fruitless. We will be paid out of the sales proceeds.
So the $23 million will come out of the sale of the property itself without any decision-making on the part of Nate Paul or World Class Holdings?
Correct.
Is that a delta of almost $18 million in loss if you had taken prior deals?
Then leading.
Sustained.
What is the difference between those values and where you ended up?
It's going to be about $17 million more than we were offered when the Attorney General was involved.
Thank you. Pass the witness.
Mr. Little.
Mr. President. Mr. Chester, how much money did your client, the Mitty Foundation, invest with Nate Paul?
$3 million. Well, in these two projects, $3 million. There were some other projects as well.
Okay, but the projects that are at issue in the litigation we are here to talk about, the Mitty Foundation invested $3 million in charitable funds with Nate Paul, correct?
With family foundation funds, yes.
Yes, and when we say family foundation funds, those are funds that were committed by the family to the charity, true?
Yes.
Okay, and of those $3 million that were invested in this program, with Nate Paul, it's really a private equity real estate deal, right?
It's a limited partnership.
Yeah, which we generally refer to as a private equity deal, right?
There's a slight nuance difference, but it's similar.
Yeah, it's very similar. You're in business litigation, correct?
Yes.
You've been in business litigation a long time, right?
Yes.
How many years?
Well, I've focused on commercial litigation about the last 10 years. Before that, I did other things.
Okay. I just want to make sure that I can harmonize this for everybody. The Midday Foundation invested $3 million with Nate Paul, and they're going to get $23 million back, right?
Right. We invested in 2010, 2011. Yes, sir.
Right. So who at the charity made the decision to invest charitable funds in a private equity real estate deal?
That would have been the board at the time.
And how many years did you say you've been doing business litigation?
Full-time, 10, off and on, my whole career.
Okay. Have you ever seen a charity make a $3 million investment in a private equity real estate deal before this?
Yes, sir.
Yeah. Do you remember the circumstance?
No, and I don't think it was exactly $3 million, but I just don't think it's an uncommon occurrence. They actually had 4 successful investments with Mr. Paul before his troubles arose.
I want to make sure that the jury heard that because I don't think I heard it very clearly. What did you say?
I said that they had a total of 6 investments, and the first 3 they made money on. The 4th one, he tried to swindle them. They still made money, and now there's 2 remaining.
Okay. But the one that you're saying Nate Paul tried to swindle them on, that's the one they're going to make $23 million. They're going to make, I'm sorry, you're shaking your head at me.
I may have misled you. The last 2 are the ones that they're going to make $23 million on. The 4th one was the one he tried to swindle them on.
Okay. That has nothing to do with the litigation.
Not really, no.
So the Midday Foundations have been the Midday Foundation's been a long-time investor with Nate Paul before having anything to do with the Attorney General. Is that right?
Yes.
Okay. During the pendency of your representation, has leadership of the Midday Foundation changed?
Yes.
And do you know a man named Dilum Chandrasoma?
I do.
And he is no longer with the foundation, is that right?
That's right.
And what were the circumstances, Mr. Chester, under which he exited that foundation?
He was arrested in 2019 for a domestic incident. The charges were later dropped, but we immediately asked him to resign.
He was accused of beating his wife and son, I think?
I don't know the details, but it was some type of domestic violence incident.
Something like that?
Charges were dropped, though.
I see. On an affidavit of non-prosecution, I'm sure, by his family, true?
I don't know, but we asked him to retire nonetheless.
Now, by the time the AG's office intervened in your pending action, your client had spent almost $800,000 or so with you, true?
Right, most of that after...
Objection, Your Honor, relevance.
Overruled.
Right, most of that after Mr. Paul defaulted on the settlement, yes.
Okay, so just to be clear, your law firm charged, and I want to make sure that we have this in order. These are charitable funds that the foundation is paying you with, right?
Yes.
And you charge that client almost $800,000, right?
At reduced
Objection,
rate,
Your Honor.
since it was a charity.
I'm sorry. Objection, Your Honor, relevance. If I could take him on a brief voir dire, I would be able to establish why attorney's fees are irrelevant to any conversation here.
Mr. President, we don't voir dire on relevance. The clear relevance of this is how the Midday Foundation uses its money. It's at issue on direct. It's at issue now.
It is also recuperated.
Overruled.
Okay. So you were charging, I believe, $450 an hour to the foundation, right?
At that time, yes.
And that's well below your rack rate of $625 at the time, right?
Might have been $715 at the time, but yes, it was well below my normal rate.
And what's your rate now?
My standard rate is $715.
Okay. And you had already, by the point the OAG's office intervened in the dispute, you had already gone through a AAA arbitration, correct?
We were just getting going in a AAA arbitration.
I'm sorry, you and I are both business litigators, so this may be a little inside baseball, but AAA is American Arbitration Association, yes?
Right.
Yes, and so what had happened was you, on behalf of your client, filed a AAA proceeding to arbitrate a dispute with Nate Paul's businesses, right?
Actually, Nate Paul filed it, but yes.
But you had counterclaims, right?
Yes, we did.
And you prevailed, right?
We won, yes.
Yeah, but to be fair, you never gave the Attorney General's office notice of that proceeding as is required by law, true?
I believe the law requires notice of a lawsuit, and there was a lawsuit, and I was a little late giving them notice.
And you were probably close to a year late, right? Something like that?
Yes. However, the lawsuit was dormant for most of that year, but yes.
I'm not being accusatory. You just didn't know.
I didn't know.
Yeah.
The judge told me, she was the former head of charitable trust, and she said, have you given the AG's office notice? I'm like, oh my God. And so I sent it the next day.
Of course, of course. So the pendency of the intervention by the Attorney General's office, it lasted a total of about 3 months, right?
Approximately.
Okay. Between us business litigators, 3 months is nothing in the life of business litigation, is it?
Well, this has been going on 5 years, so I recognize your point, but those are some crucial 3 months that cost us a lot of time and money.
Well, I want to talk about what happened during that period of time. So at some point, the Office of the Attorney General intervened, and that's, well, why don't we just go ahead and pull it out so everybody has it in the record. I'm going to show you what's been previously marked as Exhibit AG 156. May I approach the witness, Your Honor?
Thank you. Am I doing okay with the microphone? Yes, you are. Thank you.
Now, if you would, Mr. Arroyo, Exhibit AG 156. Thank you. And Mr. Chester, just tell the jury, when was this filed?
June 8th of 2020, 10 days after the stay was lifted.
Okay. Now I'm going to hand you a really big document.
Oh, my Lord.
I know. That's what I said, too. Now, this is the transcript of the hearing on your motion for sanctions. Okay?
Okay. Which one? We had about 8 of those.
You had a bunch of them, right? This one is from June 25, 2020, 17 days after the AG's office intervened.
Okay.
It's marked as AG Exhibit 13.
Ugh.
Thank you. Thank you.
Mr. Little, are you entering this into evidence?
I am, Mr. President. This is AG Exhibit 13. We move for admission.
No objection.
I was glad you say you didn't want to read it. We'd have been here for a while. No objection. Enter
Now,
0013 into evidence.
Thank you. Now, Mr. Chester, as a litigator, if the AG's office were going to intervene to help Nate Paul, your motion for sanctions and the receiver's motion for contempt and sanctions probably a pretty good time to do it, huh?
I couldn't comment on that.
Well, why don't you hold...
I'm not sure what you mean.
This is 433 pages. Why don't you just hold this booger up for the jury, if you would? Just hold it up for them so they can see it.
It's the transcript's only about a first third. The rest of it's exhibits. But
yes, and this was a lengthy hearing. You argued, you introduced evidence, offered and admitted it. True?
Yes, sir. I did my best.
It looks like you did. It looks like you did a very good job. You won this hearing, right?
I believe so. Yes.
Did the Office of the Attorney General fight for Nate Paul on any of it?
Not in this hearing.
They didn't try to keep him out of contempt. They didn't try to keep him out of discovery sanctions, did they?
Not in this hearing.
At some point in time toward the end of June, so maybe about 3 weeks or so, 2 to 3 weeks after the intervention, you were contacted about doing a mediation by someone at the AG's office, true?
I was contacted almost daily about that from the moment the intervention was filed.
And to be clear for the jury who may or may not be civil litigators, I know some of them are, mediation is just a formal settlement conference presided over by a mediator.
Yes?
Right. This would have been our third one in this case.
Yes, and so what the AG's office was proposing was to have the parties, the Mitty Foundation and the Nate Paul entities, come together with the mediator to see if they could reach a settlement. True?
Yes, it would have been the third mediation, and we'd already settled the case. But yes, sir, you're correct.
Okay. And to be clear, you could not settle the case, correct?
Explain, please.
Yeah. You couldn't settle the case, and one of the reasons was your other SEC attorneys let me try to back into this a little bit differently. How many lawyers do you have at McGinnis Lockridge?
70 or so.
Do you have securities enforcement attorneys?
Securities enforcement attorneys, no, we do not.
Okay. Do you have securities litigators at your firm?
You're looking at him.
I'm looking at him?
Yes, sir.
You're a man of many talents, aren't you? So
I know a little bit about everything and not a lot about anything.
That's great. Speaks very highly of you. So, Mr. Chester, at this point in time, one of the concerns that you had was back in 2019 when Nate Paul was raided, the SEC had someone involved in that raid, true?
That was, yes.
And one of your concerns about settling the case by the Mitty Foundation against Nate Paul and his entities was that if the SEC sued Nate Paul and got a receiver appointed, that receiver might try to disgorge the settlement. Yes?
We call that clawback, and that was a concern.
Yes, and it was a concern that you had, and a very good reason not to settle. True?
And I expressed that to the Attorney General's office on multiple occasions, yes, sir.
To whom? At the Attorney General?
Josh Godbee and Darren McCarty.
And Darren McCarty was, well, you used a word to describe him in your testimony before the House, right?
That was
what word?
That was indiscreet.
What word did you use to describe him?
It begins with an A and it ends with an E and it has 7 letters.
Okay. But you don't have any evidence that Ken Paxton ordered him to be an a-hole to you, do you?
Other than what Mr. McCarty told me.
Oh, other than what Mr. McCarty told you, no?
Right.
Okay. To be clear, maybe Darren McCarty was just born that way, right?
Or maybe he was just doing what he was told.
But you don't know either way, do you?
I don't know either way.
I didn't think so. At some point in time, bankruptcy entered the discussion in this litigation, true?
Mr. Paul filed bankruptcy 5 minutes before the deposition of his vice president of accounting. Yes, sir.
Okay, and just tell the ladies and gentlemen of the jury, what happens when you file a bankruptcy petition on behalf of an entity in litigation?
There's an automatic stay in all litigation involving that entity.
Okay. I'm going to approach you with what has been marked as Exhibit AG 212. And while I'm up there, I'm going to give you AG 41-2 to save time, okay?
Okay.
Mr. President, we move for admission of Exhibits AG 212 and 41.
41's been pre-admitted, so it's on our books.
Thank you, Mr. President.
212, any objection?
No, Your Honor. Like most exhibits, these match things we would produce on our own.
Mr. Arroyo, if you would, Exhibit AG 212.
Please admit 212 into evidence.
And Exhibit 212 is a letter from you, true?
Yes, sir.
Okay, and you're writing to Elizabeth Dykeman. Who's Elizabeth Dykeman?
She was a court administrator for one of the judges in Travis County District Court.
Okay, and you're notifying her of removing a briefing deadline, I guess, as a result of a bankruptcy filing. Is that right?
Yes, as we discussed, when the automatic stay kicks in, then everything stops, but the judges don't necessarily know that, so it's customary to notify them.
Okay, so I just want to be clear.
for one of the 3 months that the AG was intervened in this lawsuit, it was subject to the automatic stay, right?
Right, although we were litigating like crazy in bankruptcy court.
Yeah, but AG wasn't part of that, true?
I don't believe so.
They were a notice party, but they weren't part of the litigation in bankruptcy court, true?
I don't believe they appeared in bankruptcy court.
Okay, so to be fair, you're litigating with this guy on behalf of the Midday Foundation all over the place. AAA, State District Court, multiple lawsuits, bankruptcy court.
8 appeals.
8 appeals. And all that's with charitable money, right?
Yes, sir.
Okay.
Trying to get our charitable money back. Yes, sir.
And I believe you. And it sounds like you're going to get over 7 times the initial capital outlay back, right?
Long, hard fight, but yes, sir.
Okay. And to be clear for the ladies and gentlemen of the jury, in the previous 2 months before that bankruptcy filing by Nate Paul's entity in this litigation, AG's office was trying to foster a settlement between the parties, true?
They were trying to force a settlement on us.
When you say force, they can't force you to do anything, can they?
They were applying pressure. They weren't successful, but they tried.
They couldn't force you to do anything, could they?
I'll stand by my previous answer. They were trying, but they could not force us.
I appreciate your answer, but I need an answer to my question.
Okay.
The Office of the Attorney General could not force you to settle anything, true?
No, just pressure us.
No further questions.
Redirect?
No, Mr. President, thank you.
Okay. Are both sides excusing the witness?
Yes, Your Honor.
We release this witness.
Thank you.
Thank you, Mr. Chester. Very much. It's a pleasure to be here.
And we've been listening to brief testimony this morning from Ray Chester. He is an Austin civil attorney who represents the Midday Foundation.
The House calls
and
Andrew Wicker.
And was representing the Midday Foundation in litigation with Nate Paul. Drew Wicker, whose name was just called, is similarly an important witness. Ashley, he is the Paxton aide who allegedly overheard while in the Paxton home a reference to checking with Nate about the cost of an aspect of the home remodel, and that gave rise to the suspicion that Nate Paul was financing a remodel to the Paxton home.
This is the granite countertops you all have heard so much about. That, Ken Paxton saying to the crew renovating the kitchen that, well, Angela wants granite countertops and not these countertops, and someone saying, well, we've got to check with Nate. And so certainly will be interesting because some of that is what Tony Busby has said he is going to disprove. He said that during his opening statements. So it will be really interesting to see how this carries out. And Drew Wicker, someone who may not be so open to singing, for the prosecution because he is so close to the
so
Paxton,
close to them.
Considers them, family almost.
Drew Wicker is a SMU grad who went to work with Ken Paxton soon after graduating. Let's listen to his testimony.
You may proceed.
Thank you. Please state your name for the record.
Andrew James Wicker.
Mr. Wicker, it's a large room. Yeah.
Okay. Andrew James Wicker.
Thank you. I appreciate it. Tell us a little bit about your background. Where did you grow up? Where did you go to school?
I went to school at Prestonwood Christian Academy. That's where I graduated from high school. I grew up in Prosper, Texas, a little town north of Frisco, Texas, in North Dallas.
Let me pause you for a moment. Okay. Can y'all hear him well enough? Okay.
No? Okay, how about this?
Thank you, much better.
All right.
Please go ahead.
My name is Andrew James Wicker. I grew up in Prosper, Texas. I grew up going to school at Prestonwood Christian Academy, which is where I graduated from high school. I then continued on to go to SMU for undergrad, and then I went on to a graduate degree at Georgetown University.
Okay. Can you tell us a little bit about what activities you were involved in college or in while getting your master's?
In terms of my involvement in college, my first job was working for Don Huffines on his Senate campaign. And then I continued on to later be involved with founding the Young Americans for Freedom chapter at SMU, where I served as vice president. And then I helped refound the College Republicans for SMU. I ended up working with several student organizations on a 9/11 flag memorial and pro-life memorial. We had a tiff, I would say, with the administration. And so I got involved in politics in that way. And then I continued on to Georgetown and landed in DC for my graduation. And then I went to work for General Paxton.
Okay. Do you recall approximately what time or the date that you went to work for Ken Paxton?
My employment with the OAG started September of 2019.
How did you originally meet Mr. Paxton?
I had met General Paxton previously, both as my state senator, but also as the Attorney General at various Lincoln Reagan Day dinners. In terms of my employment and the opportunity to start working for him, I met him through Mark Rylander, who was a previous associate in North Texas in terms of my community. And I was recommended for the position by Mark Rylander to General Paxton. And that's whenever I met him at the Marriott Marquis in DC, and I was hired.
Okay. If Jeff Mateer was the first assistant, did Mr. Rylander have a nickname as well?
He was known commonly as the first friend.
Okay. And through that connection, you end up working at the Office of the Attorney General. In what role? What'd you do?
My title was executive aide to the Texas Attorney General, and then I was also on the campaign staff as well.
And what does an executive aide do?
My responsibilities expanded and contracted as I also had to assume scheduling responsibilities. We had 2 schedulers during my time there. Whenever we did not have a scheduler, I assumed those responsibilities, but my standard job responsibilities during whenever I was performing the functions as an executive aide was to ensure that the general was going to his schedule on time, that he was prepared for those appointments, and that he had all necessary documents and context to the discussions that he was having for that day.
That sounds like a great deal of access to the Attorney General. Is that fair?
Yes.
Approximately how much time did you spend with each other in any given day?
At least 8 hours, normally closer to probably 10.
And was that just weekdays or weekends as well?
That would include weekends.
How often was Attorney General Ken Paxton in Austin in 2020?
This was during COVID, so after probably the first 3 or 4 weeks of COVID setting in, he spent the majority of his time in Austin, starting in probably about April-May timeframe through the remainder of 2020.
And where was Senator Angela Paxton?
She regularly split her time both between their home in McKinney and in Austin.
What was your relationship with the Paxtons, individually and as a couple?
Individually, I would call General Paxton as a friend. I spent a great deal of time with him. He and I bonded over a good number of activities, such as watching football, sometimes talking politics, but just talking life. With Senator Paxton, I would say that she was nothing but loving and caring. I think she also understood that the demands of the job kept me away from my family. So in many ways, she was kind and understanding in the way that a mother would be normally. As a couple, I would say that they were incredibly welcoming and caring to me and always inclusive.
So fair to say there's no animosity or bad blood between you and the Paxtons?
Not from me, no.
Are you part of some vast conspiracy to harm them?
No.
Are you in league with TLR or the Bushes?
No.
Are you here to tell the truth?
Yes.
I'm going to turn your attention to Nate Paul. Are you familiar with that name?
Yes.
How so?
During 2020, I was introduced to Nate Paul, and there were a number of activities and discussions that revolved around Nate Paul throughout 2020.
Can you tell me the first time you remember hearing of Nate Paul or meeting him?
The first time I remember meeting Nate Paul would have been February or March of 2020. General Paxton and I met him for lunch at Terry Black's Barbecue.
Was it just the three of you?
It was.
And what was the topic of conversation?
Objection, hearsay.
Your Honor,
Sustained.
may I please respond? Anything from Ken Paxton is an admission by party opponent. Nate Paul is very clearly tied to a conspiracy, at least in terms of the evidence before this Senate, and Drew Wicker is available for cross-examination. None of that evidence is hearsay.
Again, Your Honor, the question she asked, she did not specify who was talking. Anything Nate Paul may or may not have said would be hearsay.
Sustained.
In the course of getting to know Nate Paul and Ken Paxton as a friendship, well, let me do this differently. How are the interactions between Nate Paul and Ken Paxton?
I'm sorry, can you state this question again?
Yes, sir. What was the relationship like between Nate Paul and Ken Paxton?
Objection, Your Honor. Speculation. He can testify about what he saw and maybe what he heard from Ken Paxton, but that's the extent of it.
It's foundational evidence, Your Honor. He can testify to his rational perception of the facts.
Sustained.
Did you see the two of these men interact with one another?
Yes.
And what did you see in terms of their demeanor?
A cordial relationship?
Did Mr. Paxton look to be under pressure to you?
No.
Now, I'm going to turn your attention to the second time you had lunch with them. Do you recall that?
Yes.
And where was that?
That was at Polvos, downtown in Austin.
Do you recall approximately when?
This would have been May, June timeframe.
Okay. And was anybody else present for that lunch?
Ryan Bangert.
Does Mr. Bangert work for Attorney General Ken Paxton at that point?
He did.
Is he there in his personal capacity or as part of his job duties?
He was asked by the general to attend as part of his job responsibilities.
And what was the topic of that conversation?
The Many Foundation.
Did anything change in regards to what Mr. Paul wanted between the first and the second lunch?
Objection, Your Honor. This calls for hearsay again.
Your Honor, if I may, I would really appreciate it if you would look at 801 E2D specific to co-conspirator statements.
Your Honor, there's no evidence of any silly conspiracy. This is hearsay.
This entire trial has been about a conspiracy, Your Honor.
Sustained.
Who paid for lunch?
Nate Paul.
How did you perceive their demeanor and interactions with one another, hostile or friendly?
Between Nate Paul and Ken Paxton?
Yes, sir.
Friendly.
What about Ryan Bangert? How was his demeanor?
Inquisitive.
Did he seem to agree with what it is they wanted?
Objection, Your Honor. Speculation. We've already heard from Mr. Bangert.
That is exactly why it's relevant, Your Honor. He attacked the credibility of Mr. Bangert. So it is not only not hearsay because he's a representative working for Attorney General Ken Paxton who would have adopted a belief in or offered contrary information to. In addition to that, it's a consistent statement used to rehabilitate Ryan Bangert because of their attacks.
Your Honor, I'm sorry to belabor this, but Mr. Bangert testified. And to have this witness tell us what Mr. Bangert's attitude was about some lunch 3 or 4 years ago is just improper.
Time frame has nothing to do with exceptions to hearsay, Your Honor.
Overruled.
Thank you. Can you please tell me what Ryan Bangert was saying in response to this conversation?
Okay, Your Honor, now she changed the question. And
I'm entitled to do that.
Let me finish my objection, please. Now instead of the witness answering the last question, now she's asked a clearly hearsay question.
I went more specifically at it after the court's ruling, which I'm entitled to do.
She cannot ask this witness what Ryan Bangert said. She just can't do that, and that's what she just did.
Sustained.
Thank you, Your Honor. I'm going to turn your attention to the third lunch involving Nate Paul and Ken Paxton. Can you tell me when that was?
This would have been June, July timeframe.
Of 2020?
Yes, ma'am.
And who was present at that lunch?
General Paxton, myself, and Nate Paul.
What was the topic of conversation for this lunch?
The FBI raid on Nate Paul's home and office.
Specifically, access to the affidavit underlying that search warrant?
Objection leading. And again, Your Honor, I'm sorry to interrupt, but she's asking about what Nate Paul said at a lunch. That's improper, and that would be hearsay.
Your Honor, may we approach?
You may approach.
Ashley, as we have this brief moment where the attorney for the House prosecution has asked to approach Dan Patrick, clearly there is some discussion about questions that she is wanting to ask Drew Wicker about a series of lunches. She's now on the third lunch that Wicker is testifying happened in June, around the time of June 2020. That would have been about 3 or 4 months before the whistleblowers began truly coming under the belief that Nate Paul and Ken Paxton were operating in cahoots together, and that Ken Paxton may be violating crimes in doing so.
Yeah, she's been spending time trying to ask Drew Wicker about the conversations he overheard and that he was, privy to between Nate Paul and Ken Paxton during some of these lunches. And the defense obviously has been objecting, saying it's hearsay,
right?
Which is interesting given some of the other rulings that Patrick has made, where he has allowed witnesses to testify about conversations that happened in front of them or things that they heard. And I think it's really interesting. You can see sort of some question, and obviously that's why she's there, because Busby is continuing to stop basically Wicker's testimony, and Patrick is ruling with Busby's favor. And the look on the senators' faces, particularly the senators behind this attorney, by the way, this prosecutor is Aaron Epley, and the look on their faces, the ones who are attorneys themselves at the rulings, is interesting, and that's obviously why she asked to approach.
Well, one thing I noticed too about this as well, Ashley, is that when we saw a previous House impeachment House prosecutor, Teresa Booz, questioning a witness, and we had strong and constant and consistent objections about hearsay from Ken Paxton's defense.
And from Tony Busby.
We're seeing this particular attorney, is it Epley?
Aaron Epley.
She clearly does not want to play that game, so she asked to approach the bench to possibly settle the hearsay matter prior to continuing testimony from Drew Wicker.
And I think it's interesting because Patrick was ruling, appeared to be independently on those objections, and now after they've approached the bench, and she got to the point where she was stating, giving us number and chapters that she was calling on, Patrick to look at, to show that she should be allowed to ask these questions and Drew Wicker should be permitted to answer them. Patrick now, talking with his legal counsel, and the senators that you see standing there, attorneys, Royce West, Nathan Johnson, Joan Huffman, who is formerly a judge, sitting there talking to, we would presume about
exactly. Yeah. And so again, just to rewind the tape a little bit here concerning Drew Wicker, Drew Wicker is key to this whole alleged scheme, because it was his statement that he overheard some discussion between the person, the contractor remodeling the Paxton's home, concerning who was going to pay for it, and this notion that someone needed to check with Nate about an increase in cost. And Ashley, as we can see there on the screen, Article 5 speaks to, 10, speaks to this directly, whether or not Paxton engaged in bribery, whether or not Nate Paul provided renovations to the Paxton home, and whether Paul, in fact, this is the quid pro quo, received favorable legal assistance or special access to the Attorney General's office. So this, if true, if it can be established that the Paxtons did receive a home remodel, that certainly rounds out, I think, in many ways, the House prosecution's case. But at the same time, Ashley, again, just going back to opening statements and comments that Tony Busby made in opening statements, he says it is absolutely false, categorically false, that the Paxtons received a home remodel from Nate Paul, that they paid for it themselves, and that Tony Busby plans to demonstrate through testimony and documents that the Paxton paid for their home remodel themselves.
And to stop the clock, please.
The clock stopped when you came up.
We know that you're hearing Aaron Epley ask for some time back as they continue to deal with this matter and for the clock to stop, because time is really
of the essence, literally of the essence.
We cannot even begin to explain just how critical the timing is right now. So you see right there, that's the timing format that the senators approved for this trial, and each side only gets 24 hours to question and cross-examine witnesses. At the start of the day, when we started shortly after 9 o'clock today, the prosecution had 5 hours and 17 minutes. The defense had almost double that, 9 hours, 57 minutes. And so the defense having a lot more time, and, you know, Patrick has said that they did serve notice to a jury witness yesterday that they would like to question today. We know that the prosecution wants to question, plans to question Laura Olson, because that was the first witness that they called and then had to pause because she's not eligible until 3:53 this
Although
afternoon.
we know from our colleagues at WFAA that Laura Olson is in fact on the Capitol grounds. She is in the Capitol. We have seen images of her this morning as she prepares to deliver what is expected to be, or what House impeachment managers hope will be, groundbreaking testimony in this case.
Yeah, she had walked into the Senate chamber.
To walk. Yeah, they literally called her. Yeah,
and they stopped it because not only is she required to the 24-hour notices so that both sides can prepare to question or cross-examine a witness, and so the concern was that the defense, you know, presumably didn't have enough time because they requested her late in the day. They want their full 24 hours to let that happen. Let's listen into this ruling.
We will sustain the objection.
Certainly not what the House prosecutors
not what they wanted to hear. But again, Drew Wicker's testimony is expected
of those 3 lunches in which you ate with Nate Paul and Ken Paxton, did you have occasion to be around them on other times, other occasions?
Yes.
And what kind of things would you do together? Where would you see them together?
There were 2 types of instances. The first was continued lunches, usually at Polvo's. The second was meeting at Nate Paul's place of business, and I was not part of those discussions whenever those did occur.
So to make sure that I understand, there would be times you were at lunch but not seated at the table and eating with them?
That's correct.
How many times did that occur?
Dozen and a half.
And what about trips to Nate Paul's business? How many times do you recall that happening?
At least a half dozen.
Were you ever at Nate Paul's home?
No.
And did you ever see Nate Paul join Ken Paxton at the office?
Only once.
Okay, we'll come back to that in a moment. Your Honor, at this time, the House offers House Exhibit 704, which is a public record. It is already on file, and there's a business records affidavit attached that has been on file with the court and defense for over 14 days.
Any objection once you read that?
Your Honor, there's a facial problem on this exhibit. It claims an affidavit proving up 12 pages of records, but apparently there's 23. I don't know if there's anything in here that matters, but the affidavit is improper and obviously inaccurate, unless somebody wants to correct me.
Your Honor, it's a record of the Texas Department of Public Safety, and pursuant to the rules related to public records, it would be incumbent upon Mr. Busby to establish why he thinks their records would be inaccurate. Also, the page count is likely attributable to the fact that photographs were enlarged and attached.
Again, Your Honor, she's the proponent of this document. It says it's 12 pages. It's not 12 pages. I mean, that right there gives us some element of maybe it's not trustworthy, and she's the proponent. She needs to show us why the affidavit doesn't match the documents attached. That's her job.
Your Honor, I'm confident in my response as it exists, but let me speak to my co-counsel out of a moment of respect.
May I approach and give the court a copy of what I'm looking at?
I would also add that at the conclusion of each of the records is a notification that it's a certified copy. It comes in 3 different exceptions to hearsay: business record, public record, and it's a certified copy. Additionally, I emphasize that the Attorney General works for the state of Texas, and these are state of Texas records. It's intellectually dishonest for him to fight them. Mr. President, while you're considering, can I also ask that the clock be stopped and we returned about 10 minutes between the last 2 sections of this? It's an excellent defense strategy, but it's slowing us down since we agreed to all of their exhibits, and they would not for hours.
Your Honor, I'm sorry. This is important. First off, I've been called intellectually dishonest because I look at an affidavit that says 12 pages and it's 23. And now that we're playing games because they're offering an exhibit that's clearly not what they claim it is. So I'm just making my objections, and that's all I'm doing.
Yes. You stipulated it was 12. It's 23.
Yep.
So I am going to overrule the objection because there are 5 large photographs, may account for it, and it is a government document. But I'm not giving you back the time because if you had explained this up front, we wouldn't be having this issue.
That seems fair, Mr. President. I'll go faster.
Overruled. Here's your document back.
Stacy, would you turn to, don't publish it yet, but
704 is admitted into evidence.
turn to the picture we discussed. If we were to show you a picture of Nate Paul, would you be able to identify him?
Yes.
And are you going to feel like I've led you, or if I show you the wrong picture, will you correct it?
Yes.
Yes, you'll correct me?
Yes, I will.
Thank you, sir. Permission to publish.
Yes.
Who do you see on the screen before you?
That is Nate Paul.
And is this the same person that was having lunch with Ken Paxton on those occasions and whose office that you visited?
It was.
And is this the same person who is currently facing charges in the federal courts?
Objection, hearsay, and relevance.
Sustained.
Is this the same person who was discussing the Mitty Foundation in front of you?
Objection, hearsay. We've already discussed this. This is hearsay.
He was having the conversation with Ken Paxton, who's a party opponent, Your Honor. And again, I would direct you to 801.
Overruled.
Thank you. Is this the same person who was discussing Mitty with you and Ken Paxton?
Yes.
The same person who discussed that in front of Ryan Bangert?
Yes.
And was he making requests or pressure upon the office?
Objection, hearsay.
Overruled.
What kind of things was he asking the office to do?
Objection, Your Honor. That's hearsay.
Let me go back and do it exactly the same way that he just overruled. Is this the same person who was talking to Nate Paul and Ken Paxton about Mitty?
Yes.
And what kind of things was he asking the office to do?
Objection, assumes facts not in evidence. No one's established he was asking for anything. Hearsay.
What was he asking of the office?
Again, Your Honor, she just asked the exact same question. Hearsay and assumes facts not in
I understand why he doesn't want this in, Your Honor, but can we stop the clock again?
No, we're not going to stop the clock each moment we haven't throughout the trial. If there's a long delay, I will stop the clock and give you time back. We're going to sustain the objection, and both sides need to stop the ongoing speaking objections.
Yes, Your Honor. May I get a clarification? A moment ago it was overruled and then sustained. Is Nate Paul going to be considered a co-conspirator for the purpose of this line of questioning or not?
Your Honor, before you, if I could, a conspiracy requires an agreement. Can I take the witness on voir dire to establish there's never an agreement? A conspiracy at its heart requires an agreement between two parties and then acts in furtherance of the conspiracy. There's been no evidence whatsoever in this trial. There can be no evidence in this trial of any agreement between Nate Paul and Attorney General Paxton. This witness will confirm that. I would like to take him on voir dire to establish that, and we'll put an end to all this.
If I may clarify, it is not incumbent on the sponsoring witness to establish conspiracy. That is an obligation of the court or the presiding officer. This entire case has been about Nate Paul and Ken Paxton, and I understand why they don't want it in, but that goes to weight, not admissibility, and he can be crossed on these issues. This entire trial has been about Nate Paul and Ken Paxton.
Two questions, Your Honor, to establish with this young man that there was never an agreement. He never heard an agreement, no conspiracy, and we can quit talking about that. They can use this word all day long like they've been, but they cannot establish an agreement between Nate Paul and Ken Paxton.
If I may.
We'll stop the clock for a moment.
All right, so we're listening as Drew Wicker is trying to give his testimony specifically about what Nate Paul was requesting or asking, or the conversations, the nature of the conversation between him and Ken Paxton during some of these meetings about the Mitty Foundation.
And so, Ashley, you know, we're seeing some fireworks between Tony Busby, and I want to introduce to you the House prosecutor who is questioning Mr. Wicker. Her name is Erin Epley. She is an attorney, and it looks like in a private practice.
She has
sole
her
practitioner
own,
in Houston.
Well, she has her own law firm in Houston. Yes.
And she came to play this morning.
No, Tony, she did not come to play.
Well, yeah, she did not. Yeah, well, she came to. Yeah, she's in the ring.
She is not here for Tony Busby and him trying to stop her from asking the questions she wants to have. And to her point, particularly about this conversation about, can we know a little bit more about what happened between the conversations between Ken Paxton and Nate Paul, she's saying this whole trial has been about Ken Paxton and Nate Paul. So when you have this key witness take the stand, you can't now say, oh, you can't talk about what
Well, and it seems like one of the things that she is really trying to get at is this question of, were they operating together? And that is a line of questioning that she appears to be going down, and that Tony Busby is objecting about.
And was there, sort of this bribery is what we're hearing. Was it if you do this, I'll do that?
Before we ruled on that issue, you may move forward.
Yes, Your Honor. Based on the ruling, I will proceed.
Starting back up, let's listen in.
I'm going to turn your attention to specific silos in the office. Are you comfortable with that term? Do you know what I mean? In terms of Mitty, foreclosure, open records, and Brandon Kamek or the search warrant?
Yes.
Okay. Turning your attention to the open records request, Who was in charge of the division during that relevant time period?
Ryan Vassar.
And do you recall an occasion in which you were asked to collect a file specific to an open records request?
Yes.
What were you asked to do?
I was asked to pick up those documents for Ryan Vassar and provide them to General Paxton.
Did you do that?
Yes.
What, if anything, do you recall about that package?
I recall that it was in a sealed manila envelope and it had a CD with it.
And when you say CD, I know common parlance, but can you explain specifically what you mean?
A compact disc to go into a computer to maintain digital files.
So something with structure to it that would hold additional data?
Yes.
Why do you remember it being there?
Because it was on the outside.
Where did you take that file?
General Paxton.
How long did it stay with General Paxton, or did you collect it at some point?
I did collect it at some point.
How long was it gone? How long was it with?
A week and a half.
After you collected the file, where did you return it to?
Ryan Vassar.
Do you recall during this time frame whether or not you had done any pickups or deliveries involving Nate Paul and Ken Paxton?
The deliveries that I made to Nate Paul took place in May and June.
Okay, and can you tell us about that?
There were 3 occurrences in which I met Nate Paul to pick up or deliver items. The first was to deliver a manila envelope. The second was to pick up the general's phone that he had left at Nate Paul's office. And the third was to pick up documents related to the Mitty Foundation to deliver to Ryan Bangert.
Now, you mentioned the delivery of a manila envelope. Do you recall whether that was substantially similar to the one that you had picked up from Ryan Vassar and delivered to Ken Paxton?
I do not.
Do you recall how heavy or thick the package was?
I do not.
Could you use your fingers to demonstrate for the senators, similar to the way you explained it to us the first time? What is the smallest and largest it could have been?
The smallest that it could have been would have been about this.
I'm sorry, Drew. You want to object? He already said he doesn't remember. Now he's just speculating.
Overruled.
Please go ahead.
The way I explained it to the House impeachment managers was this size to this size.
And do you recall whether or not that package had any CDs attached to it?
I do not.
Do you know if it contained any?
No.
So would you be able to tell these senators that it was in any way substantially different than from what you received from Ryan Vassar and delivered to Ken Paxton?
No.
Okay. When we first spoke, do you recall approximately when that was?
May.
Hi. May?
May of this year.
And did you want to speak with us?
No.
What did you understand at the time, whether you were correct or incorrect? What did you understand we were doing?
My understanding was that there were questions about funding the settlement of the whistleblowers.
And when you arrived, was it subsequent to a subpoena?
It was.
Was that necessary in order to have you attend?
It was.
Did you arrive alone?
No.
Who were you with?
My attorney.
Who is your attorney?
John Evans.
Is he present here today?
He is.
And why did you retain Mr. Evans?
I retained Mr. Evans 3 years ago after the events that occurred in the fall of 2020. I retained Mr. Evans after being reached out to by the FBI, and after being offered counsel by the Office of the Attorney General, I chose to retain my own counsel that would look out for my own interests.
I want to make sure that I understand. At some point, the Office of the Attorney General offered to provide you an attorney?
Yes.
Are you under the impression you had done anything wrong?
No.
Did the Office of the Attorney General indicate whether or not they wanted you to speak to FBI?
They indicated that they would not like me to speak to the FBI.
And you said to protect your interests. What concerns did you have about using their attorney as opposed to your own?
I would assume that an attorney employed by the Office of the Attorney General would look out for the interest of that institution, but not for me.
And did you feel then that your motives or your interests were not aligned?
I didn't know that they were not aligned, but I wanted to make sure that they were aligned to my interests.
Okay. When we had you come in and speak to us in May of 2023, what was your demeanor, in your opinion, when you first came in? Were you forthcoming and happy to talk?
No.
Were you honest to the best of your ability?
Yes.
And was that statement consistent with the testimony you're giving today?
Yes.
And was it consistent with the testimony, or at least the statements you had provided 3 years before that date?
Yes, they were.
I saw you hesitate. Did you correct yourself on your own at some point during the conversation with us?
I did.
What was that about?
The correction was a question by the House team asking me whether or not I had delivered documents to Nate Paul. Over the course of that discussion, I was asked about it again, and I recalled that I had in fact done so, and I have since verified with my attorney and with other law enforcement officials that that is consistent with my testimony from 3 years ago.
Thank you, sir. There was some implication that we had threatened, or I think it was Mr. Busby talking about squeezing you. Did you feel squeezed?
No.
Did we threaten you at all?
No.
Did we lead you or give you the answers?
No.
So when you made that correction, why did you do it?
I did so because I remembered something, and I had misrepresented my testimony whenever I provided an incorrect answer earlier, and so I sought to correct that.
Thank you, sir. I'm going to turn your attention then to the foreclosure, and specifically whether or not you overheard any conversations involving Ken Paxton related to the foreclosure.
Okay.
Do you recall any conversations?
I recall one conversation.
And what was that?
It was a conversation where I was in Ryan Bangert's office and overheard he and Ryan Bangert discussing...
Sorry, Drew. He who?
General Paxton and Ryan Bangert were discussing the opinion, and General Paxton asked Mr. Bangert if he had been able to reach out and contact an individual. Mr. Bangert responded that this individual had not been helpful in the matter that he had reached out about.
Let me pause you. Not helpful in what way? They just declined to assist?
I'm not completely aware, no.
Okay, go ahead.
The second part of that conversation was in which the general expressed a desire to make sure that grandmothers were not evicted from their homes, and that's where I learned about the foreclosure opinion.
Are you aware that there was a stay related to residential homes at the time?
At the time, I probably was.
So the foreclosure letter would have impacted commercial business, not residential?
Objection, leading, and speculation.
Sustained.
I'm going to turn your attention to the Omni Hotel in the summer of 2020. Were you familiar with that hotel at that time?
I was.
And why is that?
During the course of General Paxton's renovations at his home, that's where he was staying in the interim.
Okay, I'm going to come back to the renovations at his home, but help me understand, do you have any personal knowledge of Mr. Paxton being at the Omni in the summer of 2020?
I do.
How's that?
General Paxton called off his protective detail for the time that he was staying at the Omni Hotel. And as part of my job responsibilities, I picked him up and dropped him off each day to the Omni Hotel.
Did Mr. Paxton drop his security detail on few or many occasions in 2020?
It came in spurts.
Help me understand spurts. What would that frequency be?
There were times at which it was highly frequent and I was his primary means of transportation, and there were other times at which we utilized the protective detail.
And while we're on the topic, so that I can move a little faster, what about items being on a schedule? Was everything he did through OAG or personally reflected on a schedule?
No.
Is the schedule supposed to contain the comings and goings of the Attorney General?
More generally, yes.
Why is that?
For the assistance of DPS specifically, I would provide a 2-week outlook on the schedule so that they could understand where appointments were, what time, who their POC was at that place and time, so that they could coordinate security efforts.
And were there occasions in which Mr. Paxton's plans were not contained on his schedule?
Yes.
Specifically related to Nate Paul?
Yes.
How do you know that?
Because I manage the schedule.
Did you have concerns about that at the time?
No.
At some point, did it become concerning enough to you for you to speak to a supervisor?
Yes.
Who was your supervisor?
Blake Brickman.
And why would you go to Blake Brickman about such a concern?
I was receiving some new requests in terms of both transportation as well as documentation and scheduling, and I was trying to understand the best way to handle that with my boss, who is General Paxton.
Okay. I'm going to return you back to the Omni. On one occasion, were you there with your family?
Yes.
Can you quickly tell the Senate why you were there and for how long?
My family had come down for a weekend. I don't recall if there was any sort of special significance for that occasion. They were down there to stay there for the weekend. General Paxton was also there at that time due to the renovations being conducted on his home, and they were staying down there, and I chose to stay with them for the time that they were at that hotel as well.
Did you have occasion to see Ken Paxton while you were there?
I did run into him, yes.
Can you please tell us about that?
My mom and sister had gone up to the hotel room. My father and I had run back to my apartment downtown. Upon returning to the Omni Hotel and entering the lobby, we turned right to go into the elevators. We had pushed the button and were waiting on the elevators, and on the other side of the door, my father and I heard a lively discussion. Just to be clear, not adversarial, just lively. And whenever the doors opened, two individuals exited. One was General Paxton. He was in workout attire, and he told us that he was going to the gym. The other individual was in a dress and high heels and exited rather quickly. General Paxton walked out, shook my hand as well as my father's. We spoke for a moment, and then he told us he was going to work out.
Was there anyone else on the elevator for which that lively conversation could have included?
No.
And what, if anything, did you notice about the dynamic between the two, if anything at all?
I couldn't overhear the conversation, but whenever they exited, she quickly exited the elevator, and that was the only time I really saw them interact in person.
Did that cause any concern for you or questions?
It did spur some questions.
And who would you have directed those questions to?
I reached out to Mark Rylander about that.
And why did you reach out to Mark Rylander?
Prior to coming to the office of the Attorney General, I had been informed that there had been...
Objection, hearsay.
Sustained.
Did you have reason to think, whether true or not true on the part of Mr. Rylander, this might be something of interest to him?
Objection. Yes. Again, Your Honor, she's just trying to ask a different way. This is based on hearsay.
Overruled.
Did you have any reason to think this might be of interest to him?
Yes.
And was it?
Yes.
Did he seem to understand who it was you had seen?
Yes.
Did you receive a photograph to confirm?
Yes.
Now, I'm not going to show you the same photograph, but I am going to show you a person. Would you be able to tell me if this was the person that you saw in the elevator?
Yes.
May I approach? So used to government work, I forget we have technology. Can I turn everyone's attention to 704? And Stacy, would you pull up the photograph, please? Do you recognize the person in this picture, whether you know her name or not?
I do.
For purposes of the record, the person being depicted in the photograph is Laura Olson, as established by her Texas driver's license. Thank you, Stacy. I have $6.99. Next, Your Honor, the House offers Exhibit 699. It is a business record as established by the affidavit on the face. I'm confident that the page count will match this time, as there's no substantial photographs, and it has been on record for over 14 days. And it is being admitted by agreement, as I understand it.
Any objection?
No objection, Your Honor.
Admit Exhibit 699 into evidence.
Now, Mr. Wicker, I'm not going to have you do this, but inside of an apartment complex application, would it explain where you have lived before and where you're going to live now? I know that didn't make sense. Are you aware of the fact that application leases will establish your prior address as well as your current one?
Yes.
And is the name on that record the same as the driver's license, Laura Olson?
It is.
Is that the woman that you saw step off the elevator with Ken Paxton?
It is.
You mentioned home renovations. Do you remember why those renovations were occurring?
There were storms late spring that caused water damage to General Paxton's Austin home.
Okay. I don't want you to give the address, but could you give us the street name so that we're all familiar with the fact that we're speaking about the same thing?
Margarinita Crescent.
So you said spring. Do you recall what month the damage occurred in?
This probably would have occurred March, April timeframe.
Okay. And do you know where the damage was?
To the best of my recollection, it was confined to the master bedroom.
Why would you know that?
I met with the insurance adjuster multiple times at the request of General Paxton while he was out of town or in other meetings.
So there were occasions where you were authorized on his behalf to conduct personal business, for example, the adjustment of the insurance?
I was authorized to greet the insurance adjuster and show them the home.
Does that mean you would sometimes also receive records related to the home renovation?
I can only think of one occurrence in which that happened.
And what was that?
I received an invoice that I had been included on from the STEAM team.
And are you aware, as the adjuster, that there are some renovations that were done pursuant to the water damage itself and covered by insurance?
I would assume so, yes.
I'm going to turn everyone's attention to House Exhibit 703. Again, it's a business record. It's Cupertino Builders. There's a business record affidavit, and it's been on file for over 14 days.
Any objection?
No, sir.
Admit 703 into evidence.
Stacy, would you please pull up the face of the email that's attached? Mr. Wicker, do you recognize the name of the individual who sent the email?
Kevin Wood.
And who is Kevin Wood?
Kevin Wood was the lead contractor at the Paxton's home renovation.
Is he someone that you met personally?
He is.
How many times did you see or speak with Kevin Wood?
At least a half dozen.
And do you see that on the to line is the name Raj Kumar?
I see yes, I do.
And moving down further, do you see that Nate Paul or N Paul at worldclass.com was the person who emailed Kevin Wood?
I do.
Where is that? What are we looking at?
Is the body of that email related to home items or repairs, things that need to be done?
It would appear so, yes.
I'm going to have Stacy then turn to the first couple of pictures in the file. Can we see the next? Does anything about the home being depicted look familiar to you?
Several of these images do appear to be, that's the Paxton's dining room.
Are you wondering or are you sure?
No, I'm positive.
Thank you. On how many occasions were you at the Margarinita home in the summer of 2020 during renovations?
During the renovations, half dozen.
Okay. And do you recall any times that you were present where Kevin Wood and Ken Paxton were both there?
I do.
I'm going to turn your attention to a conversation about the kitchen. Do you recall whether or not there was any damage to that area of the home?
I do not.
Would it make sense then that these are things external to insurance coverage?
It would make sense.
Is that an area of the home that you ever discussed in regards to being an adjuster or assisting the adjuster, rather?
Not to my recollection.
Okay. Can you walk us through any conversations you overheard between Kevin Wood and Ken Paxton?
Objection, Your Honor. Anything Kevin Wood may have said would be hearsay.
At this stage, Your Honor, it's not being offered for the truth. It's to set an anchor. I will get more specific in a moment.
Again, Your Honor, the question is very nonspecific, and anything she's going to ask about what Kevin Wood may have said is hearsay.
Your Honor, it is clear from the course of the conversation that Kevin Wood was acting as a service provider. At that point, the truth doesn't matter. At the point in which it does, it goes to his motive, intent, and plan.
Again, Your Honor, you've already... She just said what Kevin Wood said wouldn't matter. I agree. Hearsay and irrelevant.
I didn't say it ultimately wouldn't matter, Your Honor. It will matter very much.
Sustain.
Did you get an idea as to what the relationship was between Ken Paxton and Kevin Wood?
Kevin Wood was the lead contractor on General Paxton's home.
And if Mr. Paxton then wanted additional things or changes to the renovation, whom would he speak with?
Kevin Wood.
Is there any other way Mr. Paxton would find out the timing of renovations or the duration of renovations or the cost of renovations other than Kevin Wood?
Objection, compound, and speculation. She is asking what Ken Paxton would do and what he would know. That's pure speculation.
It's an operative fact, Your Honor. There's no other way for him to know it.
Again, she just asked what Ken Paxton might know. That's speculation.
I'm going to overrule. You can answer if you know.
Not to my knowledge.
I don't even remember the question at this point, frankly. I might have to read it back. At any point, were there conversations about changes to the property?
Yes.
Isn't that the entire point of a contractor?
Yes.
And at any point, were there discussions about particular items in the home?
Yes.
Would what matters to you be whether a counter is granted or not, or whether the renovations are occurring at this stage?
Objection, vague, and relevance.
Did you care what his countertops were made of?
Again, Your Honor, what does it matter whether young Drew Wicker cares about the countertops? It's irrelevant.
Overrule.
Did you care what the countertops were made of?
No.
Did anything about a conversation related to countertops concern you?
Objection, hearsay.
It is not being offered for the truth of the matter asserted. There's no statement. It asks if he overheard something he was concerned about.
She just asked for hearsay right there, Your Honor. That's hearsay.
No, Your Honor, it goes to state of mind.
Overruled.
Thank you. At some point, did you hear something that concerned you?
Yes.
What was that?
Objection, hearsay.
Your Honor, there's three places. One, nucleus of operative facts, because it goes to the center of this. Specific to hearsay, it goes to state of mind. There's no other way for General Paxton to know how long something is going to take or what it will cost other than speaking to his contractor. And finally, it goes to Drew Wicker's state of mind in regards to what he does next because of what he heard, whether the statement is true or not.
Your Honor, we need to know who she's talking about was speaking. I think she's trying to elicit testimony about what this man heard a contractor say who has been subpoenaed and who could come here and testify. This is not the right witness for that.
I'm going to overrule. You're not saying it's the truth of the matter, just the statement was made.
That's at this point, Your Honor. Mr. President, thank you. What did you hear that concerned you?
Kevin Wood stated that he would check with Nate on several of the items.
Now, was that about how long something would take or when something would be delivered?
No, sir. No, ma'am. It was with regards to cost.
Now, if Kevin Wood's a contractor who's trying to make money on his own, why would he need to check with anyone?
Objection, speculation.
Sustained.
So let's back up a little bit. What would he have to check with Nate on specifically? Please tell us in detail what you recall.
He was stating that he would need to check with Nate on the cost of countertops and renovations to the cabinetry in the kitchen.
I'm going to be very specific. Did he have to check on the cost, or did he have to check on, did Mr. Wood seem to already understand what the cost would be?
Yes.
And what was the cost?
He mentioned the total of $20,000
For what?
for the cabinetry and the countertops.
And what was Ken Paxton's response? That he wanted to do it or did not want to do it?
He stated that he would like to move forward.
And then what was said by Kevin Wood?
He said, I would check with Nate.
Did you relay that conversation to anyone?
I related to 2 individuals.
Were either of them people who worked above you at the Office of the Attorney General?
Yes.
Were you relaying the information to be salacious or for another reason?
I was seeking advice.
And who did you speak to?
I spoke to Mark Rylander and Blake Brickman.
What did Mark Rylander or Blake Brickman advise you to do?
Objection, hearsay.
Your Honor, Okay. What did you do after speaking to Mark Rylander and Blake Brickman?
I spoke to General Paxton.
What did you say to Mr. General Paxton?
I asked him about the conversation that I'd overheard, and I stated that I walked away with a certain impression.
Let me pause you. With what impression?
I walked away with the impression that Nate Paul was involved in the renovations of General Paxton's home.
What concerns did you have about that?
Given the fact that we were working on several items related to Mr. Paul, it felt as though there might be an inappropriate relationship there.
Were you that clear with the general?
Yes.
And what happened?
He stated that he appreciated me bringing his concern to him, and that he then assured me that that was in fact not the case.
Did his explanation absolve all concerns?
No.
How did you feel at the conclusion of that conversation?
Still uneasy, but I never discussed it after that with him.
Okay. Are you aware of the fact that we've issued subpoenas for Kevin Wood for him to address these issues and that he does not intend to testify before this court?
Objection, speculation. She's just testifying now.
Sustained.
Did you spend much time at the Paxton home after that?
Not much, no.
Why not?
It was a mix of ongoing renovations, increased travel, and just lack of requests to be there.
Okay. Did you feel comfortable about the home or being present at the home?
Not always, no.
Why is that?
There were still some lingering concerns over the questions that I had asked the general, but I had not followed up on those concerns.
In the summer of 2020, prior to the whistleblowing allegations, did you have an opinion as to the veracity or the truthfulness of Mark Penley?
Yes.
And what was it?
He seemed to be an individual of the utmost integrity.
And did you have an opinion as to the credibility or truthfulness of Jeff Mateer?
Yes.
I'm sorry, it's not proper for one witness to talk about whether another witness is truthful. That's just not how it works.
It absolutely is, Your Honor.
So please let me finish and quit interrupting, please. Your Honor, it's not proper for one witness to sit up on the stand and say, this person's truthful, that's not how it works. It's improper. I object.
He's absolutely right in a vacuum. I would have no authority to talk about the character of truthfulness as a primary rule, and I wouldn't infringe it. But once he attacks their credibility, Rule 405A1 allows me to establish by reputation or opinion a relevant character trait. In this case, truthfulness.
That's not how it works, Your Honor.
Yes, it is.
Anyway, this is not how it works, Your Honor. You don't get up here and bring one witness and talk about the veracity of all the other witnesses. Now, if she feels like Mr. Penley's veracity was challenged on some particular statement, then she brings a different statement to try to rehabilitate him. But she don't do it with this witness.
You could do it with any witness, Your Honor.
Will sustain the objection.
How did you communicate with Ken Paxton in 2020?
Through email and text message and phone calls.
How many cell phones did Ken Paxton have?
He had 2 primary, and he later obtained 2 more cell phones.
I learned through the course of opening that I used the term burner phone incorrectly. Apparently, they have to be cheap and from 7-Eleven. What would you call extra phones that most people don't know about?
Extra phones.
Okay, so two primary phones, 2 extra phones.
Yes, ma'am.
Do you have the phone number of his personal phone?
I do.
And would you give us the last 4 digits of that, please?
The cell phone is 8128.
And what about his work phone?
0220.
Can you describe for us physically what the other 2 phones look like?
The other 2 phones being the extra phones?
That's correct.
Okay. The other 2 phones, one was a Samsung Galaxy Fold, the other was a red iPhone.
You mentioned that you also communicated with him by email. Outside of work email, did he have another?
He did.
What kind of account was that?
It was a Proton mail.
And do you know how the Proton account was set up?
It was set up through the OAG's office.
Why was that?
We went to China.
So it was safer to discuss business on that phone than it would be for a Chinese hacker to get into a personal cell or a work cell, correct?
Yes.
But do you also know that their headquarters are out of the United States?
I believe they're in Switzerland.
And so they wouldn't be subsequent to a search warrant and are not provided as part of a public records request to the OAG.
Objection, speculation, Your Honor.
Sustain.
And are you familiar with something called Signal?
I am.
What is that?
It is an encrypted messaging app.
Encrypted, also making it safer, correct?
Yes.
Are you aware that they too are housed out of the country, not subsequent to, or not under the pressures of a subpoena and not provided by the OAG?
Again, Your Honor, this is just her testifying what she thinks Signal is. This witness doesn't know this. It's speculation and improper.
Sustain.
At any point, did General Paxton ask to use technology that you provided?
Yes.
What was that?
He used my personal cell phone.
How many times did the general use your personal cell phone?
At least 3 to 4.
Were you able to hear those conversations or who they were with?
I was not.
Were you able to determine after you got your property back why he needed your phone?
No.
Why not?
Whenever I received my cellular device back, the call log had been wiped.
And did he use anything of yours other than your cell phone?
No.
Do you recall after the whistleblowers, Mr. Paxton asking to use your laptop?
Yes.
What was that about?
That was a request. He was working on a letter to the Inspector General of the United States.
Can you anchor that in time for us? What had just occurred?
This was late October, and this would have been after the whistleblower complaint.
And do you know, what were you asked to do?
I was asked, General Paxton handed me a hard copy of a document and asked me to transcribe the events outlined in the document in the form of a letter to the Inspector General.
And by hard copy, you mean like what I have here?
Yes.
So not handwriting, but typed written?
Yes.
Why would you need to be provided a typed written copy of anything that's already in electronic format?
Objection, speculation.
Overruled.
Why would you need to be provided a hand copy of anything that's already in electronic format?
I don't know.
And what were you asked to do? Transcribe, you said?
Yes.
Were you making additions or deletions?
I did make several additions, yes.
What kind of additions?
Since it was asked to be in the format of a letter to Inspector General Horowitz, it was addressed to Inspector General Horowitz. There was a slight introduction that I'd been asked to include, and then this sign-off was asked to be as General Paxton.
At this time, I offer House Exhibit 573. This is part of the Office of the Attorney General records. There is a business record affidavit. It has been on file for greater than 14 days.
Any objection?
Do we know about this? No objection, Your Honor.
Please admit Exhibit 573 into evidence.
Mr. Wicker, will you take a moment and look at the body of that letter and let me know if you recognize it?
This is the letter that I was asked to write for Inspector General Horowitz.
So if I turn you to the top where you add Dear Mr. Horowitz, you typed that in?
Yes.
Do you know who that is?
He was or is the Inspector General of the United States.
We've heard about the Office of the Inspector General throughout this trial. Do you know whether or not that's the appropriate person to go to if you want to make complaints about federal prosecutors or federal agents?
That is my understanding, yes.
At any point prior to the whistleblow situation, had Ken Paxton talked to you about, or in your presence, about the Office of the Attorney General?
About the Office of the Attorney General, yes.
Had he ever suggested going there, or that they were the correct place to bring this complaint?
He had not mentioned that to me, no.
In fact, do you know that he didn't want to take it to OIG prior to that?
Objection, speculation.
Overruled.
Do you know whether or not he wanted to take Nate Paul's complaint to the OIG prior to the whistleblowers coming forward?
I do not.
And then once you look at this letter, I'm going to turn you down to the bottom in regards to the allegations made by Nate Paul, and I'm going to go quickly. Did these amount to things like not getting to use the restroom?
It did.
And when you drafted it, did you realize part of Nate Paul's big federal complaint is that he couldn't call his attorney except from using an agent's cell phone?
Yes.
And that he was not allowed to call for counsel, and that's why they provided him a cell phone?
Yes.
Are you aware that the only allegations he makes, well, let me do this differently. Where were you when you were helping type this up for the general?
This letter was written in the Office of the Attorney General.
On what laptop?
My state laptop.
And what did you do with the laptop after typing up the letter?
I followed up with General Paxton about having completed the transcribed letter.
And then what?
And I asked him what he'd like to do with it.
And what was the response?
He said that he had several insertions that he would like to make, and that he would let me know about when he needed it.
Did he have you email him or put it into a USB drive?
Not to my recollection, no.
What did he do?
He asked me to bring my state laptop to his Austin home so that he could work on the letter.
And did he make changes to your knowledge?
To my knowledge, no.
Okay. Okay. After drafting the letter for the Attorney General, do you know whether or not the letter was ever sent to OIG?
I do not.
Let me turn your attention then to the conclusion of your career there. What was the status of your job?
The status was that I was both the scheduler as well as the executive aide.
Well, I mean, at the end, in October of 2020, leading into November. Were you offered a promotion? Were you offered a change in job function?
I was.
And what was that?
General Paxton had expressed an interest in myself taking on greater responsibilities with regards to certain policy areas, and that I would continue with my present job responsibilities, but also take on the additional policy-related responsibilities.
And at some point you'd mentioned that FBI had reached out to you and you make Ken Paxton aware of that. Is that accurate?
Yes.
And what did he do?
General Paxton's question that he asked me was, why?
Did you have a response for him?
No, I did not.
What, if anything, did he direct you to do?
He did not direct me to do anything at that time.
Did he take you anywhere?
Not at that time, no.
Okay, ultimately, you say not at that time, so what happens next in regards to that?
The next discussion I had with a member of the AG staff regarding the FBI was Brent Webster requested to meet with me.
And what, if anything, did Brent Webster have to say on behalf of the Office of the Attorney General?
Objection, hearsay, Your Honor.
Sustained.
Was he working in his official capacity as a representative or employee of the Office of the Attorney General?
That is my understanding, yes.
Same question, Your Honor, subsequent to 801 ED, which is specific to representatives or employees. Brett Webster is making the comment to Mr. Wicker in his capacity as an employee of Ken Paxton.
It's the same objection, Your Honor. We've established in this trial, that's not how it works. She cannot just come up here and ask him what somebody else said other than General Paxton himself.
You can when he's being directed as part of his employment.
He's not an employee of Ken Paxton.
He's an agent of Ken Paxton, so we'll overrule.
Thank you. What, if anything, did Brent Webster tell you?
Mr. Webster said that he understood that the FBI had reached out to me and that I should not respond.
Did he tell you why?
He said that I ran the risk of incriminating myself.
And did he then bring you back to Ken Paxton?
Eventually, yes.
What was that conversation about?
He believed that there was an opportunity to assert attorney-client privilege.
So he too wanted to prevent you from speaking to FBI?
It certainly seems that way, yes.
And were you asked to speak to anyone else about this?
Leslie French.
And what did she tell you to do?
Leslie French advised me that she had been through something similar and that there was nothing to worry about, that the AG's office would provide me with counsel while I met with the FBI, and that there was no need for me to bring my own counsel.
What was your response?
My response was that I would feel more comfortable retaining my own counsel that would look out for my interests.
Why did you respond that way?
Because that's how I would have felt comfortable in that instance.
After all of this, what decision do you ultimately make about this promotion?
The conversation that occurred regarding the promotion was all at once, and this was actually, I informed General Paxton that I would not be taking the promotion, but I would gladly accept the responsibilities.
Why were you making that distinction?
I did not want the general to have the appearance of having offered me anything in light of the FBI reaching out.
So you were trying to protect the appearance of what that would look like for General Paxton?
For General Paxton and myself.
Thank you. Did you ultimately put in your notice and quit?
I did resign, yes.
Was that on November 2nd, 2020?
If I recall correctly, yes.
Makes sense then that payments would stop, is that correct?
Yes.
And did they stop from the Office of the Attorney General?
They did.
Did they stop overall?
No.
What else were you provided?
I was continued to be provided a monthly stipend by the campaign.
Did you notify Ken Paxton's campaign that you were still receiving money and that you should not be?
No, I had let them know that I was leaving and to cut off my access to both the email and the calendar, and that I should cease receiving stipends.
When did you cease receiving stipends?
Not until the following year.
And what, if anything, did you do with that extra money that you had been provided?
Michelle Smith had sent me a W-2 with that amount. I contacted her, not understanding that I continued to be paid. I asked her what I should do with the money and if General Paxton would like it back. She reached out to General Paxton, who informed her to tell me to keep it. And I stated no problem, and I went ahead and donated the money back.
They told you to keep it and you donated it back?
Yes.
Why did you do that?
I didn't do the work.
How did you feel about receiving money from Ken Paxton's campaign after you ceased employment and in light of all the facts relevant today?
I have no reason to believe that it was with malicious intent. It might have been an innocent mistake.
I think maybe more specifically, I'm talking about your character. What made you return it?
I didn't put in the work, and I did not want any instance, I didn't want it to appear as though I might have any conflict of interest if anything like this ever came about.
Thank you, sir. Pass the witness.
We're going to take a break now, and members, we went longer in this section, so we'll take a 20-minute break, and then we'll go till 12:30. We'll move lunch 12:30 to 1:30 today. So be back here at 15 minutes after 11.
And we have been listening to testimony from Drew Wicker, who grew up in North Texas, attended SMU before heading to Georgetown, and worked for a couple of years as Ken Paxton's scheduler and right-hand man, essentially, and through that had very intimate interactions with Ken Paxton, talked about being in his home a half dozen times, particularly as a home remodel was going on. And Ashley, that home remodel, and particularly those countertops, are an underpinning, really, of this whole case in terms of whether or not Ken Paxton was receiving a benefit from his help to Nate Paul. Drew Wicker talking about a conversation that he was a party to or overheard, in which Ken Paxton was talking to an Austin contractor by the name of Kevin Wood. Kevin Wood and Ken Paxton were talking about the cost of some countertops. There was a conversation, according to Drew Wicker, in which Ken Paxton, or there was a conversation about the need to check with Nate Paul for the cost of that $20,000 kitchen remodel. Again, that $20,000 cost would have been for cabinetry and for countertops. According to Drew Wicker, Ken Paxton said that he would, in fact, like to move forward with that project. So again, the kitchen remodel, really sort of an underpinning to the house's claim that Ken Paxton was receiving benefits from his aid to Nate Paul. Drew Wicker went on to say that he flagged this issue multiple times with other staff within the Attorney General's office. He also says he confronted Ken Paxton himself, and that he left that interaction with, quote, the impression that Nate Paul was involved in the renovation of the Paxton home. He went on to say, it felt as though, this is a direct quote, it felt as though there might be an inappropriate relationship there. According to Wicker's testimony, he was then offered a promotion within the Attorney General's office with greater policy responsibility. He also reported that by then, around that time, the FBI also had reached out to Drew Wicker, and that he notified Ken Paxton that he had in fact been contacted by the FBI. That's important because obviously this would have been after the whistleblowers reported Ken Paxton to the FBI. Soon after that, according to Drew Wicker, Ken Paxton's newly installed first assistant by the name of Brent Webster suggested or directed him not to respond to the FBI because Wicker ran the risk of incriminating himself. His testimony, his direct testimony by the House prosecutor Aaron Epley, concluded with also something that was striking in that Drew Wicker reported that he put in his notice and that he left the Attorney General's office in November 2020. Yes, appropriately, he says, his payment from the state agency itself stopped. But of particular note, he says, is that Paxton's campaign continued paying him a monthly stipend. He did not disclose the amount of that stipend, but he said the next year he was contacted by Michelle Smith, who is also an ally of the Paxtons, both Angela and Ken Paxton, and was told to keep the money. Drew Wicker says that he did not keep the money, that he donated it back because, quote, I didn't do the work. So certainly some testimony that I think in the minds, Ashley, of many people watching this testimony and listening to this testimony this morning, in many ways advanced the House's case here.
I think it did, and I think it's almost troubling to think about the second part of what you told us that Wicker testified to today. So this ordeal with the renovation of the kitchen and having to check with Nate is something that I would say, expected to hear. This was in the House manager's case. Yeah. We've seen documents
foundational to it.
Yes, I mean it's related to one of the articles of impeachment. I believe it's Article
Andrew,
10.
Andrew, can you pop up that article? There it is,
right.
Ashley.
So that's Article 10 of constitutional bribery, basically alleging Paul Nate Paul, that Austin real estate developer, of giving Paxton home renovations, and specifically a renovation, a $20,000 renovation to the kitchen of the Paxton's home. This is around the time that the Paxton's home had an insurance claim due to some water
for
damage
the bedroom, for the master bedroom.
For the master bedroom. And Wicker said that because he would often meet with the contractor, the real estate adjuster, because Paxton had meetings and things to do, and so he would step in for him. But in addition to that going on in the house, there was also the kitchen being renovated, which was not covered by the insurance claim. So we expected to hear that. And Wicker notably, said he didn't want to talk to the House prosecution when this first happened.
Only did so pursuant to a subpoena.
To a subpoena. He had to be subpoenaed to even talk to them. And so I would say we expected to hear this. We expected to hear the details of this. Tony, I certainly was not expecting to hear that after he made the decision of his own will to resign from this office, that Ken Paxton would then continue to pay him.
Through the campaign, not taxpayer money.
So not with taxpayer money, but would continue to pay him through the campaign for months. Because this is in November, and he said he got paid well into the next year, and he actually received a W-2 from the campaign, noting how much he had been paid in that monthly stipend, the money that he received, and that Paxton told him to keep the money. And they told him to keep paying him and for him to keep the money.
I mean, the suggestion being made by House managers there is that it was a payoff.
That is certainly
it was hush money.
Hush money, which is, obviously when we look at those catch-all articles of impeachment against Ken Paxton, that he's unfit for office, this certainly would speak to that in their case. Again, there were 20 articles of impeachment against Paxton. This particular trial is for 16 of those 20 articles of impeachment. And I think that listening to Drew Wicker's testimony, who, again, this is someone who is not a whistleblower. This is someone who, I think to all accounts we can say, is not a rhino. This is a very conservative Republican who was serving the Attorney General, that he actually at one point turned down, after the FBI had reached out to him, had turned down a promotion, said
with greater policy responsibility,
which is something that he obviously aspired to, and said, I'll do the work, but I won't take the title because I don't want it to look like you promoted me as the FBI is trying to question me, to protect you, General Paxton, and frankly to protect myself throughout all this. So this is someone who's not a whistleblower, not a rhino, not the establishment, testifying to some, I would say, pretty damning testimony. Tony, this is really key to the prosecution's case. And so I think that testimony is going to be hard to reconcile for the Republican senators in this chamber who are sitting on the fence, who aren't sure, are weighing whether or not they're going to convict or acquit.
Unless Tony Busby has something up his, and he may. I mean, we'll see soon after this break, or once cross-examination begins. Actually, I think the other thing that struck out to me, and I certainly don't want to insult Mr. Wicker, but we're talking about, in terms of the allegations that were brought forth by those 8 whistleblowers, certainly with the exception of one of them, they were all attorneys. They were all highly experienced attorneys. The 8th whistleblower, David Maxwell, was a very experienced law enforcement officer. And then you have, in Tony Busby's words, young Drew Wicker, he called him, who certainly felt as though something was not sitting right or sitting well, and took that information to his colleagues in the executive floor for advice in the executive level. And I also think too, when you think about the way he didn't use the word confront, but clearly he checked it out with the Attorney General with regard to saying, I did not feel comfortable with this conversation that I overheard. Very, very noteworthy, I think.
I think so too. And again, that he went to them for advice after hearing this. And it wasn't I'm trying to tell or I think something is up. It's just I am younger in this position. What should we do here? One of the things you mentioned, Tony, is, it's going to be interesting to see Crossing if Tony Buzbee has something up his sleeve. And I'll tell you, one thing he has up his sleeve is time. Significantly more time, more than double the amount of time that the prosecution has. And because the prosecution is sort of running through its time this morning, they only had 5 hours left. And so it almost felt like Wicker's testimony was a little bit rushed. Mm-hmm. She kind of mentioned the time.
And she was asking for time back?
She was asking for Aaron Epley. This is the attorney who was questioning Wicker for the prosecution. At one point, she looked at the table and did a 5-5, like she's trying to check the time. Mm-hmm. And so you would imagine how much more his testimony would have been fleshed out if they had had the time. And I think Tony Buzbee, in true Tony Buzbee fashion, and the showmanship that he gives us, I think he's going to take the time to make the arguments, to make the statements, to flesh out testimony. We'll hear some of those dramatic pauses. We'll hear some of those. Well, wait, you mean to tell me? You know how Tony Buzbee likes to do, and then he'll kind of create that.
Let's let that sink in.
Yes, with lots of things that he'll be able to do, that he has, frankly, the time to do, that the House doesn't. And then the House prosecutors are going to have to be really thinking about what they want to attack on their redirect, because again, they're running out of time. And they're running out of time when we know we have a major witness.
A major witness who they are going to presumably they will want to take their time with.
They will want to take their time. We're talking about Laura Olson, who is Ken Paxton's mistress, who was here. She was set to be called this morning, and she walked into the chamber and was about to come through the doors. And the defense kind of said, well, wait a minute, let's talk about this. It has not been a full 24 hours, and we agreed we would get 24 hours notice to a witness so that
3:53.
Yeah, so that each side would have time to prepare to question that witness, and that notice wasn't given to her until 3:53 p.m. yesterday. So that, certainly buys the prosecution a little more time, and buys the defense a little more time, and eats away at the prosecution's time.
More broadly, Ashley, I think this is just an interesting conversation about the degree to which Drew Wicker's testimony sort of reframes this whole thing. I can tell you that talking to Republican people associated with Republican politics here in Texas last night and early today, there was a growing concern that, not a concern, but a growing belief that the prosecution, the House managers, really were not proving up their case, and that they had not really even begun to address these bribery allegations. And so we certainly see that turn. I can also tell you that just on the political front, it is my understanding that some of the House Republicans in the House who voted to move the articles of impeachment from the House to the Senate, which of course led to this trial that we are seeing this weekend last, that some of them, that there was growing frustration among Republicans, some Republicans in the House, that they did not believe that the House prosecution was delivering on some of the promises that they had made back in May when these articles of impeachment were delivered. So that was a growing contention among some of the House Republicans as recently as last night and this morning.
But I think one of the things that, I think it's all, and one of the things that when I lean back on what Brad Vinson told us, an Austin attorney, or James Webster, so these are two attorneys that we had in here offering legal analysis of this trial with us, who talked about the strategy that they would need to use. We have spent the other witnesses up until Drew Wicker. We have listened to them lay out all these other articles of impeachment. There are only 2 articles directly, when we're taking out the 4 catch-all articles, there are only 2 articles directly related to the bribery, right? And that's right. The more salacious,
yes.
Certainly charges against him. Those other articles are
about abuse of office,
about rewriting documents, violating the public records,
going against your staff,
doing it wrongful opinions, hiring Brandon Kamick and violating the law and how you hire him. And so I think we've also been watching them go in order, if you will, of how they're attacking this. And so I think that while some may be getting frustrated that they had not gotten there yet, well, we were going to get there, and I think it was intentional that we're going to end there.
The state's case. I keep saying the state. I mean the prosecution.
Because they want to end on an emotional. They want to end on powerful.
Like a mic drop moment.
Exactly, and you're going to get that from a Laura Olson, from a Drew Wicker. You weren't going to get that from Jeff Mateer, no offense to Mateer, or Ryan Bangert or Ryan Vassar. They weren't going to give you that. Certainly, we ended the first week with that. With
David Maxwell, yes.
And so I think we saw that's the intention here. It was slow and methodical off the top, intentionally so. And I think it's going to be interesting to see how they close. But, it's not over till it's over.
And here's the other question. Will it matter in the end? Are they going to,
be a fly on the wall.
Yeah, I mean, that's the other, I think, kind of underlying question here is whether or not Tony Busby and Dan Cogdell and Anthony Osso and that whole team, whether or not they have provided the Republican senators enough, and I'm going to use this word here, whether or not they have provided them enough cover that they can vote to acquit. I say cover, others might say enough factual basis to vote to acquit. I mean, and that's the open question.
Because you have the conservative machine saying, "Oh, there's been no evidence." Well,
capital M and machine.
Yes,
I mean, they are
absolutely
out there on social media, doing mailers. Framing this in a way that
senators that there's been no evidence, and there was tweets this morning about we're going to have to vote them out. You've got to go if they're going to have to go. When this is really while it is a political trial, they also took an oath to find truth and to rule based on that truth, and so I think as a Texan, if I take off my journalist hat and I put on my native Texan hat, it's kind of hard for me to watch because I want to see them given the respect to rule on how they want to rule. And I think we ought to respect the process a little bit more. This is significant. This is not something that has happened in more than 100 years that we've seen a statewide official be impeached. Frankly, it would be nice to see the politics taken out of it and for them to rule on what is right and what is wrong and lay it down like that, and that these things, I wish these things weren't coming into play, right?
But we know that they are. I mean, when you look at things like
wake up from the fairy tale.
Yeah, well, but in all seriousness, when we know, for example, that there are PACs out there, for example, the Defend Texas Liberty PAC has poured money into this effort, that they have said out loud in a very direct and clear way that they will work to oust any Republican who votes against Ken Paxton. I mean, certainly we have seen and will likely continue to see the infusion of politics into this whole process. I mean, the attorneys we have had and any of the attorneys who we have talked to correctly point out that none of these people who are the jurors in this case would ever be chosen as jurors given their proximity to this matter. I mean, we know that Laura Olson, the Paxton mistress, worked for State Senator Donna Campbell. We know that State Senator Brian Hughes, for example, lived with Ken Paxton. They were roommates and friends. We know that Brian Hughes, of course, was directly involved in soliciting an opinion from the Attorney General's office that was said to be or was, in fact, advantageous to Nate Paul. And again, the picture with Laura Olson with Lieutenant Governor Dan Patrick certainly underscoring at least some knowledge of one another there. So obviously this is not a standard civil or criminal trial in any way, shape, or form. But this is the process that is in place. It is set forth by the state constitution. And so here we are, and here we are maybe for not much longer. I mean, this may be, may reach a conclusion, Ashley, by the weekend or early next week, if not sooner.
Yeah. Lieutenant Governor Dan Patrick telling the parties that they would essentially be out of their time, out of their 24-hour time frame that they have to present and cross-examine by Thursday, that they would be out of time Thursday. And naturally, so what's going to happen after they hit the clock, right, on those 48 hours total, each side will get an hour to present rebuttal evidence, and then there will be an hour for closing arguments, those final statements. Each will have an hour, and then it will go to the senators. And we've heard that the senators are not, Dan Patrick said, not going to stop until it is over. There will be no days off. There will be no, going home. They will be in there working until, and I say home as in their home districts. Right. There will be no leaving until it is all said.
Including on Sunday, which we know that typically speaking, the senators are loath to work on those Sundays. Yeah. We can see as we conclude in the next 5 minutes or so, this 20-minute break, some of the senators trickling back into their desk. Ashley, we can't forget as we listen to this testimony, certainly by some characterizations, this damning testimony, we can't forget, Ashley, that there are a number of senators, minimum of 5 or 6, but maybe more, up to 10, just going back to that very first day. There were some senators who did not believe that any of this information should be heard, that there should not have been a trial. And I think that is an important dimension of this as well, an effort to frankly stifle the truth that has come out.
Well, and there were 6 senators who were hard and fast on those votes of the motions, right? That's what we're talking about, is how they voted on the motions. And there were motions to dismiss one or all of the charges against Ken Paxton, and you only needed a simple majority in order for that to pass. So we're talking about 16 senators out of the 30 who were voting. And they never reached that because there were always a set of senators, 6. Well, we never reached that, but there was always a set of senators, 6, who were hard and fast. They did not want this trial to happen. And there were a few, between 2 and 4 other senators who swung back and forth.
Again, typically, though, the senators who voted against the trial, by no surprise, were the harder right, more conservative senators who, shared the same political views, political philosophies, Christian conservative values as Ken Paxton.
Yeah. And senators returning now. It's 11:17. They were told to be back on the floor from this break at 11:15 for us to move forward. Just some timing notes. Dan Patrick saying that they were going to likely break for lunch at 12:30 until 1:30. At which time we'll come back, and we still won't be at 3:53, which means we still won't be Laura Olson available to take the stand. Now, I don't know. They said over the lunch break, obviously the sides are going to talk about a few things. Maybe they'll reconcile that.
Well, I was just about to say maybe the defense at some point just concedes that. Look, right. I mean, she's here. We know she is on the Capitol grounds. Our colleagues have gotten photographs and videos of her in the chamber.
And so then the question is,
or not in the chamber, excuse me, in the hallway.
Is Dan Patrick inclined to take a break until that time frame runs out so that they can call her? Is he more inclined to say, nope, you should have served her, you should have given her that notice?
That's actually a really good question too. Yeah.
Because if I'm the defense, let me just say this, I don't want Laura Olson to take the stand.
No way.
If I'm the defense attorney. This woman is subject of one of the articles of impeachment. I believe it is Article 11 that alleges that Nate Paul hired her to work for him as a benefit or bribery.
Right,
because
there
this
it
is
is.
the constitutional bribery. It's actually Article 9. Not 11. I couldn't remember which came
I'm
first,
terrible
this
with
one or the
Roman
home.
numerals, by the way.
I know that the home bribery was 10. I couldn't remember if this one was first or after that one. But that, basically that Paul hired her so that she could be closer to him, and that is one
from San Antonio,
where she was living, and that. So that, that was a benefit that he received, he being Paxton received as part of helping Paul with his legal matters and the federal investigation into him. If you take a look at the dais, I'm sorry, you can't see the dais because we're showing you this full screen. But there we go. If you take a look at the dais now, you can see that Dan Paxton. Can you tell I need more coffee?
Hey, it's been a long few days.
Dan Patrick and his legal team approaching. Now you see State Senator Angela Paxton, Ken Paxton's wife, on the rail there. She was having some conversation with someone, but they're about to get back started here with the cross-examination of Drew Wicker by Tony Busby.
Certainly going to be interesting. We've seen Tony Busby and that whole team, by the way, clearly take aggressive postures toward the witnesses in this case.
And aggressive postures also, let's talk about this for a moment, with the women who are on the prosecution team. When they're talking about, or when Tony Busby is addressing prosecutor Aaron Epley, when he was addressing Teresa Boose, the way he is doing that is not sitting well with some people.
Yeah, and I think that, as we have pointed out, Aaron Epley really isn't taking it. I mean, she came prepared. She came with her own gloves on, and has swung back.
Yeah, I think Aaron Epley really studied Busby, and you have to think about this. They're both two Houston attorneys. It's clear that she's clearly studied Busby, his style, the objections he's making, because what you're hearing her cite are legal, code and precedent and the rules of a trial. She's literally telling the number and the chapter and asking Dan Patrick, well, can you please check this one and insert number here that says, she's following the rules and sort of calling Busby on the rules here. He clearly an experienced, and I say more experienced just when we look at age, right? Tony Busby is obviously older than Aaron Epley, pushing back on some of that, but she's coming, with receipts, as they say, as to why she should be able to ask the questions that she wants to ask. So certainly interesting tone and demeanor from what's happening in this trial between the two of them. Tony, is there anything in particular you're interested in seeing Busby sort of attack or go after Wicker on?
I mean, I think that, look, as we have seen with previous witnesses, Tony Busby has a way of coming up with things that, to many people may seem seemingly innocuous, but consistently we have seen Ken Paxton supporters and members of the Republican Party, really take those things and elevate them in a way that is convincing to at least many people in the court of public opinion. Of course, it will all come down to what the Senate jurors think, but that has been a consistent practice by Tony Busby and his legal team, be it Mitch Little or Andrew Osso or Dan Cogdell.
I think we're definitely going to see Busby go after the envelopes that.
Yeah, you didn't know what was in the envelope. Right, what difference does it make?
And what we're talking about is, Drew Wicker is who gave Nate Paul some documents at some point from Paxton and his team, and we know that from previous testimony, what is said to have been given to him were sealed documents about those raids at his properties by those federal investigators.
I think you can also anticipate that Tony Busby is going to try to slice up Wicker too, with regard to the conversation of we need to talk to Nate about the price of
about
you
the
know,
countertops.
well, how do you know it was Nate Paul, and what made you think it was Nate Paul, and aren't there other people in the universe named Nate who may have had direct involvement in the project? I mean,
and are you sure that's what you heard? There's so much going around. There's
exactly,
construction
the
happening in
buzz saws, all of that. So. You know, and how many occasions did you hear a reference to Nate? I mean, you can imagine that all of those things will be part of the cross-examination. And again, Ashley, I mean, the standard here for senators to convict is beyond a reasonable doubt. So all Tony Buzbee really has to do is leave a seed of doubt in the minds of those senators. Well, maybe there was another Nate, or maybe he didn't hear it correctly. You know, I think it will just be interesting to see how that goes once it gets started. Clearly, they are working through some issues regarding, well, I don't know what regarding, but hopefully in just the next few minutes here, we will be getting underway.
Like when we talk about seeds of doubt, these are not your average jurors. These are attorneys, doctors, former judges, law enforcement officers. The senators have extensive professional backgrounds. They also are not people who we take to be naive.
Right.
You know, they are an older body.
But again, it's the infusion of politics,
and
though. That's where it gets tricky. Exactly. Because if they are inclined, if they walked into this whole process inclined to acquit Ken Paxton, sizing up their own political liability for ousting him, that is where it becomes difficult. They are possibly in a difficult situation where they have to weigh all of these facts versus political liability, and maybe some truly held belief that the prosecution has not met its burden.
Right, and that very well, you know, I think could be the case here, where there was a very heavy burden placed on the House for 16 of these articles of impeachment, and did you prove that?
And there are jurors who go back to it. Look, if we are going to overturn the will of 4 million Texas voters who supported Ken Paxton, who went to the poll to cast their ballot for him, and what was, you know, frankly, a very hard-fought primary against George P. Bush. And yeah, I think it is just a very difficult, they see it, many of these Republican senators, as a very difficult proposition.
And can we just take a moment to talk about what you just said about the 4 million registered, you know, the 4 million voters.
We've heard that multiple times.
Right, who voted for Ken Paxton. And that number stands out to me because at the time of this election, I was just double checking. I had a number in my head. I was double checking my number. There are 17 million registered voters.
Where are the people voting?
Where are the voters?
Yeah.
You know, and that's interesting that, you know, Ken Paxton did hands down win. I would say easily won the election, his election, in terms of the AG election. But my goodness, it was only 4 million people made the decision for 17 million because people don't, or a state with 29 million people in it, because people don't vote.
And you know, certainly that particularly the runoff between he and George P. Was spurred such an interesting national conversation about the Republican Party here in Texas, whether or not the Texas was you know, more Trump Republicans versus the Bush dynasty, and how long that legacy would remain in Texas politics.
And before we even got to that runoff, I mean, there was a contentious, it was a four-way race. You had a Texas Supreme Court Justice step down, Eva Guzman, so that she could run. You had Congressman Louis Gohmert, who decided not to seek re-election in his own race, but to challenge. And that really struck at the conservative vote. I mean, let's be honest, that is how it ended up in a runoff.
Right.
You split
the conservative vote
between Paxton and Louis Gohmert. And so.
But all of that, I mean, we're going back in time because all of that is also on the minds, presumably, of these jurors. And Ken Paxton's defense has worked to make sure it is top of mind for these jurors as they go into this.
Well, and also because it raises the question of how much of this did people know at the time that they elected him? Because one of the arguments from the defense is that none of this is new. The affair, the fact that he was having an affair, that was not new information to anyone. You know, the fact that he's been indicted, because 4 of the articles of impeachment, the 4 that we are not hearing, are related to his securities fraud charges, though that's the federal indictment.
State indictment, yeah.
The state indictment against him. State charges, not federal charges. There's a federal investigation, but there are no federal charges against Ken Paxton. They indicted on state charges. But that's related to that. And they say, well, that's known. That's been known. That's old news. That case is 8 years old now. And so voters knew about this. But that is one of the articles. When we talk about the catch-all articles, those final 4 articles of impeachment, they deal with him depriving voters of the opportunity to get this information and to really make a sound decision on the ballot, in the ballot box, because of, the cover-up, they would say, that he engaged in.
And just for a quick reset here, it's 11:30 in the morning on what is now the, 4th, 5th, 6th, 7th day of testimony.
Day 7.
In the historic Ken Paxton impeachment trial. We continue to be on a recess that was initially supposed to be about 20 minutes. We're stretching considerably further in that. Lieutenant Governor Dan Patra, the presiding officer, has said that testimony will continue until 12:30, at which time we will take a lunch break. Those lunch breaks, by the way, have been relatively brief, about, maybe an hour or even slightly less.
And I'm wondering if we're going to hold true to that. We were supposed to get started back here at 11:15, so I wonder how true we will hold to that 12:30. Given where we are.
Give us a minute. Jurors were resolving some issues here.
They're still needing
still resolving some issues. But I mean, again, Ashley, it's interesting because of I think certainly public interest in this proceeding remains high, but we can presume that many people will turn the dial later this afternoon with the testimony of Laura Olson. Again, certainly, as we have discussed, there is a salacious sort of quality to that will draw public interest. But the reality is, the reason this affair is of substance to this proceeding is that Ken Paxton is accused of obtaining a job for his mistress, Laura Olson, from Nate Paul. That along with this home remodel were the 2 main benefits that Ken Paxton is said to have received as a result and as a benefit for helping Nate Paul.
And the possibility of what else does Laura Olson know? This is a woman who Missy Carey testified. Paxton said he loved her.
Yes.
He was not going to stop the affair because of that. Let's actually listen in on this about this objection and what's happening.
A motion for reconsideration and amendment of the Senate Rule 27 and 30A.
Please bring it forward.
Yes, sir.
As I rush to look up what Senate
those rules are.
Motion members, you will have an opportunity to do that later. In short, they want to amend the rules so that after deliberations, when you vote for acquittal or conviction, if you vote for conviction, it automatically prevents the Attorney General from serving in office. Again, they want to combine that. That's what the motion is. It has to lay out for 24 hours. It's 11:30, so we would not take it up until 11:30 tomorrow, and that will come to you to do with as you decide. You can table it, you can take it up, whatever you decide. So I want you to be aware of that motion because that's the proper procedure. If the parties are making a motion to bring it to me, and for me to share it with you. Mr. Busby.
Thank you, Your Honor. Is it okay if I call you Drew? Turn your mic on there.
There we go. Is this better?
Okay?
Yes, sir. That is okay.
I hope you don't think I'm being disrespectful.
No, go ahead.
We did speak on the phone a couple of nights ago.
Yes, sir.
Okay. And you also talked to these folks over here as well?
Yes, sir.
Okay. I want to clear something up. When you were working as an aide to General Paxton, you were getting paid not only from the state, but also from his campaign.
Yes, sir. That is correct.
Because you were doing some things not only for the state, but you were doing other business for General Paxton.
Correct.
And so it would make sense that you would be paid by both entities.
Yes, sir.
And as I understand it, you were getting paid direct deposit by the campaign?
Yes, sir.
Okay, so just to clear this up, when you decided to leave the AG's office and go and work in your family's business, somebody forgot to turn off your direct deposit from the campaign.
Yes, sir.
It wasn't somebody like still giving you checks, it was just an automatic direct deposit.
Objection, speculation.
I mean, you know how you're getting paid in your own bank account.
I'll sustain the objection, but you can ask again.
You know how you were getting paid. It was a direct deposit into your bank account, wasn't it?
That's correct.
And it just continued until you raised the issue and then you gave the money back, right?
Objection, speculation.
We've already heard from this.
Overruled.
Isn't that what happened when it was figured out? General Paxton said, well, just keep the money, Drew, and you decided, no, the better thing to do is just give it back to the campaign, right?
That is correct.
Okay. You talked about 3 lunches in your direct, did you not?
I did.
These were at restaurants?
Yes, sir.
In a public place?
Yes, sir.
Was anybody hiding or in a secret dark back room?
Not to my knowledge.
Anybody that walked in the restaurant could see General Paxton there, could see you there, could see whoever he was having lunch with there, right?
That is correct.
Wasn't anything secret about that at all, was there?
No, sir.
Okay. I want to make sure the members understand, Drew, because this is some things that you not only told the House when you were interviewed, but you also told me the other night on the phone. When you were working for General Paxton, you almost considered him family, didn't you?
That is correct.
You have no animosity towards the Paxtons, do you?
I do not.
And you told me you love the General, right?
That is correct.
And you also said you appreciate everything that General Paxton did for you.
Correct.
The Paxtons used to joke that you were a second son, didn't they?
They did.
You told me that you and General Paxton were very close.
That's correct.
Are you accusing, and I don't think you are, I just want to make it clear, because you were probably with General Paxton more than anyone else during that time frame that you were working for him, weren't you?
Yes.
I mean, I want to make it clear. I think that the senators know, but just for the public, sometimes you would be what's called a body man. You ever heard that term?
Yes, I've heard that term.
Yeah, and basically you're with your boss all the time until he releases you for the day.
That is correct.
So you would have been spending more time with General Paxton than anyone else, right?
Yes.
More so than even his wife, Angela.
Yes.
You're not accusing him of bribery, are you?
I'm not.
Let's be clear. The guy that spent more time, and that's you, Drew, with General Paxton than anyone else during the time frame that we're here to talk about is absolutely not accusing General Paxton of doing anything wrong at all, are you?
I'm not accusing anybody of anything, no.
Okay. You also were with General Paxton when he traveled, right?
That's correct.
And just so, and I know you've read some of these press reports, haven't you?
I've done my best to stay away from any sort of media. I've had some people say some things to me, but I've tried to shut that down as soon as it's come up.
And I know it's hard to ignore some of this stuff in the newspaper, but you know that there's been an allegation that General Paxton had a secret email address?
I believe you mentioned that to me on the call the other day, yes.
And you and I know that the reason he had that Proton address, that email address, was because he was traveling to China.
That is correct.
And the reason and that was something set up for him by the IT department at the Office of Attorney General.
That is correct.
And that email address was to prevent the Chinese from hacking into his into his email, right?
Correct.
Okay. And other people in the office had that same type of email address, didn't they?
I don't know how many others, but yes.
Okay. You remember the suggestion of burner phones?
Miss Epley mentioned it earlier, but yes.
Yeah, it was, and I know you probably haven't been reading the newspaper, but let's just go ahead and get this out of the way. If a burner phone is a phone, a plastic phone that you can buy at a convenience store with a certain amount of minutes, and when it's over, you break it and throw it in the trash. General Paxton never had anything like that, did he?
Not to my knowledge, no.
He never had any burner phone, did he?
Not under that definition, no, sir.
Okay. You told the House you could not speculate as to what relationship Nate Paul had with General Paxton. Isn't that right?
I stated that I believe that they were friends, yes. But I wouldn't speculate beyond that.
Yeah, that's all you know, right?
Yes.
Okay. One thing you do know, that you never were in the presence of General Paxton when he and Nate Paul made any kind of agreement. Isn't that right?
That is correct.
I mean, let's be clear. They've been throwing around this word conspiracy for literally a week and almost a half, and you were the man who was with General Paxton more than anyone else, and you can say definitively, you never saw Nate Paul and General Paxton reach any sort of agreement whatsoever. Isn't that right?
No, sir.
Is that right?
For the conversations I was privy to, that is an accurate statement. Yes, sir.
Okay. You don't have any actual knowledge that Nate Paul ever did anything for General Paxton other than buy a lunch. Isn't that right?
That is correct.
Let's be clear. The man that was with General Paxton more than anyone else is testifying under oath that you have no evidence, no knowledge that Nate Paul ever did anything for General Paxton other than buy a lunch. Isn't that true?
That is correct.
Now, you have seen some speculation in the newspaper and the press, haven't you?
Prior to this trial, yes.
Yeah. And I want to, and I'm not picking on you, Drew, because I think you can tell that I'm fond of you and I like you. But I want you to know that this whole idea of the house renovations, everybody says it came from you. Do you know anything about who paid for General Paxton's home renovations?
Not directly, no.
All you have is one stray comment, right?
Across multiple instances, yes.
And you were concerned about it and you went and raised it with your boss, right?
That is correct.
And he was very clear with you. That is not what's going on here. Isn't that right?
That is what he stated to me, yes.
Okay. When you interviewed with the house managers, did they ever bother to show you the receipts, bills, payments related to General Paxton's house renovations?
No, sir.
They are in evidence. Did you ever go with General Paxton and Senator Paxton when they went to Home Depot?
No, sir.
When they went to Lowe's?
No, sir.
When they went to a different Lowe's?
No, sir.
Were you ever with them when they were pricing sinks and countertops?
No, sir.
You did say in your testimony to the House that General Paxton's, I don't want to use the wrong word, but he's close with his money.
Yes.
I don't want to call him cheap because he's my client, but he pays attention to what he spends.
The word I would use is frugal.
Frugal, good word, okay. You believed, based on what some people have told you or maybe what you read, that General Paxton got granite countertops?
That was what I read in one news article, yes.
Okay, let's let that sink in. And when you read that, and when you connected it to the statement you say you heard, you thought, well, there it is. General Paxton got granite countertops paid for by Nate Paul, right?
No, sir.
You still didn't believe that, did you?
No, sir. In terms of the timing, I had already made my statements to the House committee, and the article that I read and am referencing now, I believe, came out after that.
Okay, and I'm not talking about that. I just want to make sure that at some point in time, you believed that General Paxton had gotten granite countertops, right?
I had heard that. I don't think I believed that. No, sir.
Do you believe it now?
No, sir.
Let's pull up, Eric, if you will, Attorney General Exhibit 371. You told us you had been in the kitchen of the Paxton's home in Austin.
I was.
And that's in Terrytown here in Austin?
That is my understanding what the neighborhood's called, yes.
Okay. Can we pull that up, Eric, please?
Objection, Your Honor. Is this already in evidence? And he hasn't established the relevant time period, whether it was before or after.
I've already said this is in evidence, Your Honor. It's AG 371.
Overruled.
Now, this picture, sir, was taken a few days before this trial started. Do you see the countertops?
Objection assumes facts not in evidence.
It's already been proved up, Your Honor. We'll do it again.
It has not been proven up. It is a photograph, and it depicts exactly what it reports to until or unless he lays a predicate for someone who can say when it was taken.
If I could keep going, Your Honor, we'll do all that.
Same.
Sir, do you see the kitchen, the Paxton kitchen there?
I do.
Do you see the countertops?
I do.
Are those the same countertops that you saw when you were in the Paxton kitchen?
Prior to the renovation, yes.
Okay. Do you realize that that's the same countertops as they exist today?
Objection, facts not in evidence. He doesn't have a predicate for that, and he's testifying to the Senate.
Your Honor, this has already come into evidence of the current picture of General Paxton's kitchen. It's already in
This
evidence.
characterization of the evidence, Your Honor, the photograph is in evidence, but what it depicts has not been established, and Tony Busby does not get to, no matter how hard he tries, establish the time frame in which it was taken.
Again,
Sustained.
is this how the kitchen looked when you were in it?
Prior to the renovations, yes.
Okay. Do you see the countertops?
I do.
Do you see the stove?
I do.
Do you see the cabinetry?
I do.
Okay. Do you know how often the Paxtons went and priced new stoves, new countertops, painting the cabinetry? Do you know?
Objection assumes facts not in evidence. We don't know that they did that at all.
I'm asking him, Your Honor. How can I establish if I don't ask him that?
Overruled.
Do you know how many times they did that?
I do not.
Wouldn't it be unfair to the Paxtons to suggest that this picture here...
Objection to relevance is the way it's phrased, Your Honor.
Let
It's
him finish his
inappropriate.
question.
Do you know whether the countertops that we see in this picture, do you know whether they've ever changed?
I do not know if they've changed now.
Okay. In evidence is Exhibit 346 to 353. You mentioned Steam Clean as one of the contractors, right?
Yes, sir.
And you had to deal with them?
I believe I was copied on email correspondence.
Okay. And did you know that there was more work that the Paxtons wanted beyond what Steam Clean was going to do?
I wasn't that involved in the detail of the STEAM team.
Okay. Did you talk to us about how you had some involvement with an insurance adjuster?
The involvement being that I showed him the home? Yes.
And the insurance company was USAA?
I believe that's correct.
Let's look at what's in evidence. AG Exhibit 410, second page. Just catch the first page first, Eric. Can you confirm with me, Mr. Wicker, Drew, that the date of this correspondence from USAA is September 16th, 2020?
I can.
And let's turn to the second page. Do you see that the policyholder is Warren Paxton, your former boss?
Yes.
Okay. And you see there's a claim number there?
I do.
And do you see this explanation for the benefits and the payments and the additional payments that are laid out there?
That's what it appears to be, yes.
And how often did you hear General Paxton complain about how slow the insurance company was on his claim?
Objection, Your Honor. What's good for the goose is good for the gander. That's hearsay.
Exactly. We've been hearing from General Paxton all trial.
He's our party opponent, Your Honor, not his own. He cannot proffer statements for Ken Paxton on his behalf from the stand. We get to use them against him. He doesn't get to offer them for you.
Sustained.
Do you see here it says $32,000 total cash out to you for all other covered repairs? Do you see that?
I do.
Did you ever have any involvement in trying to convince the mortgage company to release that check to the Paxtons?
I don't recall that now.
Okay. Did you understand that there were more repairs being made that Ken Paxton was claiming were covered from a different contractor?
Objection assumes facts, not in evidence, and counselors testifying.
Did you know?
Sustained.
Did you know that there was a different contractor doing some of the work in the Paxton's home?
Objection, Mr. Busby. That's twice the judge has sustained the objection to facts, not in evidence.
He just testified to it in direct that he dealt with Kevin Wood.
Yeah.
That's in evidence.
That's because it was a direct relationship based on his rational perception of the facts.
Did you deal with Mr. Wood? Did you see Mr. Wood at the home?
I did deal with Mr. Wood, yes.
Did you know that he was doing repairs and renovations to the home?
Yes.
Did you know that he was in fact the second contractor that's being referred to in the USAA docs?
No, I've never seen these documents.
Objection assumes facts, not in evidence. He's introduced a second contractor when all we know is the first and Cupertino.
I'm trying to figure out how it would be that Nate Paul's paying for repairs when in fact USAA is paying for some of them. You have any idea about that?
General Paxton expressed to me that he was paying things out of his own pocket as well as insurance.
Exactly. You knew that, for instance, the sink that they put into the home, you know that sink was replaced, right?
Objection assumes facts, not in evidence.
I'm asking him, Your Honor, how can we put it in evidence if I don't ask the witness?
Overruled.
Silly objections. You know that they were trying to replace their sink, right?
No, sir, I do not know that.
Okay. Do you know what the sink looks like now?
No, sir.
Do you know who paid for the sink?
No, sir.
Your Honor, we're going to offer AG Exhibit 433, which is all the pictures.
Objection, Your Honor.
That Angela, let me offer the exhibit first. All of the pictures that Angela Paxton had from her phone, all of these, where they were at Lowe's and Home Depot, pricing repairs to their home that they paid for out of their own pocket.
Objection, Your Honor. Assumes facts, not in evidence.
Excuse me, Counselor. Let him finish. Okay. You have plenty of time to object.
With an affidavit from Senator Paxton herself, establishing that these are records that they keep, that they kept, and she confirms that they are what she say they are, and they're non-hearsay. They're mostly just pictures.
Your Honor, Mr. President, if I may respond.
Exhibit 433, all the pictures from Angela Paxton's phone.
I'm not calling Senator Paxton's credibility on this issue.
Excuse me 1 second.
Into question.
Let me ask you, do you object?
I do.
What basis?
I am not calling the affidavit itself into question. What I am saying is there is inadequate information in that packet to establish it as relevant. For example, there are about 300 pages of what looks like scrolling online shopping or photographs from catalogs from Home Depot and Lowe's. They have no point of relevance. You don't know when the pictures were taken or by whom. So while she can establish they are her records, we do not know what they imply. There's nothing to show us what they fairly and accurately depict or when it was taken.
That's what the affidavit
Mr.
does.
Busby.
The affidavit specifically does what she claims it doesn't do.
She does not claim the time frame or when the pictures were taken.
Right here, Your Honor.
Can I see the affidavit?
You may.
And so this is one of the things that Tony Busby promised he was going to show the jurors.
Mr. President, I would point out that their business record affidavit has not
one
been
of the
on file
claims
for
he
14
says he's
days,
going
and
to
no metadata
dismantle.
is that
if they'd done a
the
Celebrate drum of the
Paxtons
cell phone.
had their kitchen renovation paid for by Paul, and he talked about, I'm going to show you pictures of them shopping in Home Depot, picking things out. And so interesting to hear how the defense is describing these photos, which are not pictures or, selfies of the Paxtons in Home Depot, but rather pictures of
catalogs
or, screenshots or pictures of things. And to the prosecution's point, we don't know who took those pictures. We don't know when those pictures were taken. And
the
there's
real
300
relevance.
of them.
The real relevance.
How does this prove that they themselves paid for the kitchen? And I just want people to not get so caught up in these granite countertops. I mean, that's what I think we're going to hear about
forever,
over and over, is whether or not the countertops are granite, even though they said they wanted granite. They don't have granite countertops in their kitchen now. The point of all of that, Tony.
Yeah, and, I think one thing that is a little striking too about this cross-examination is the tone that Tony Busby is taking with Drew Wicker. I mean, Drew Wicker has established that he had a very close relationship with the Paxtons, far more personal than I think the other whistleblowers.
The defense has not followed the rules established by this body in order to have a senator testify, which is de facto what is happening by affidavit. I want to encourage everyone to realize I'm not questioning that she signed what she believes to be a valid affidavit. It's that it is not in compliance with the rules, and it does not tell us what it purports to depict.
Your Honor, our mission here, this is Article 10, our mission here is to find the truth. And they have alleged that Ken Paxton and Angela Paxton, a member of this body, were bribed, that someone else paid for their house repairs. The documents you have in your hand directly contradict that, and in fact prove the opposite. Those are proved up by affidavit. The pictures fairly and accurately represent pictures they were taking when they were pricing at Lowe's and Home Depot. They also have pictures of the house itself as it was undergoing renovations, and I'll compare those pictures with the pictures of the home now to demonstrate that all the things Angela Paxton wanted, like a new sink, she got.
Objection, Your Honor. Counsel continues to testify on behalf of his client. It is inappropriate. I ask that we approach and that the testimony be stricken and the senator's asked to disregard. I am not attacking a senator here, but he has to follow the rules of evidence because this is a court and we follow the rules.
Come on up. Come on up.
And so what you're hearing them talk about is related to the affidavit. So in addition to the photos that they want to submit of countertops and
fixtures and
things that they wanted in this home repair, they also want to submit an affidavit from State Senator Angela Paxton saying that these are explaining, if you will, what these pictures are. And the point that, the prosecution is making in all of this is that, well, you can't do that because there are rules about testimony from a senator, which do not include submitting affidavits. If you want, something from Angela Paxton included, then you've got to go through the rules to have her as a witness.
And we know, we know from the reporting of our colleagues that Angela Paxton's name apparently was on an initial witness list that was issued, but then her name was not on a subsequent list. So I think there was a discussion as well about whether or not her information is going to be submitted as part of this.
So I'll tell you, I'm frantically going through the 29 pages of rules to see if I can find this exact rule where they're talking about the senators themselves being witnesses. And I believe it's under conflicts because there are numerous members of this body who have conflicts.
And keep in mind, just as a reminder, that Angela Paxton is constitutionally required to be in the impeachment hearing. She does not get an ultimate vote, however, but as we have seen, she's there every day. Her husband is not there every day, but she is there every day.
Has not been there a full day.
Has not been there, it has not been there a full day period. He came pursuant to the rules to be present when his plea of not guilty was entered, but we have not seen or heard from him since. And we've been talking about sort of the implications of that, whether or not that plays well for him or does not play well for him. I mean, certainly there is the appearance that he is taking a stand against what he has called a farce of a process, that this whole impeachment effort has been weaponized against him. But at this point, we're also, as we approach the noon hour, we're seeing senators begin sort of milling about as this effort, as this discussion, rather, this debate, this conflict about whether or not an affidavit from Angela Paxton is going to be submitted into evidence, according to Tony Buzbee, establishing that she and her husband, the Attorney General, went shopping to a couple of different Home Depots and other stores. They were taking pictures of things that they were apparently picking out. You know, Ashley, just one question I have about that, and maybe Mr. Buzbee will take us through this. It remains to be seen. But just because they picked certain things out doesn't necessarily mean that they paid for it either.
Well, no, and I think one of the things, and so let's point this out, based on what Tony Buzbee said during his opening statement, that he's going to show where USAA sent that check to the Paxtons. And you know what? Before I even go there, let's take a step back even further. Let's take a step back even further to some of the documents that the House presented that is evidence that everybody can look at. This was in response to the motions that were being filed. They, in that stack of evidence, those dozens of pages of documents, allege that Ken Paxton did in fact pay for a renovation, that he sent a check, but that it was after the House managers, after the whistleblowers told him that they had reported him to the FBI.
Like within day, maybe the next day. The next day, yes.
So this is how it goes, is that the House whistleblowers go to the FBI. The next day, those whistleblowers tell Paxton, we reported you to the FBI. We think you're doing things that, you know, are questionable, unethical, illegal. And the next day, Paxton then sends a $20,000 payment to
Cupertino Builders, it's called. Yeah.
And so, you know, Tony Buzbee has said, so you have to keep that clear. Keep in mind that's what they're alleging.
Cupertino Builders, just as a quick side note, is a company that has been in legal trouble, as I just want to confirm that, has had issues of its own, and also, as part of that, has a link to Nate Paul.
Right. And so with that, Buzbee says he's going to prove, though, that the insurance approves, you know, during this time frame, the insurance approves the settlement. They send the payment to the Paxtons, and that's the payment that the Paxtons send on. But what we heard from Drew Wicker is the insurance wasn't paying for the kitchen renovation. The insurance was paying for renovations to the master bedroom of the house, which happened as a result. They had an insurance claim because there were some spring storms in Austin that caused water damage to the master bedroom only. And so the insurance claim, the source of the claim was the master bedroom. And so I think there's almost an effort to say, to confuse the two.
Conflate them.
Yeah, absolutely. To say, well, did that money pay for, you know, which one was the insurance paying for and which one was supposedly Nate Paul paying for. And so now we're getting into, I would say, the weeds.
Yeah.
In terms of which sink did Angela Paxton want and which countertops did she want and did she ultimately get those? I mean,
the degree to which that matters.
Right. It's the weeds. It doesn't matter. What matters is who paid for it.
But it matters with regard to creating, as we've seen, those seeds of doubt.
Well, sure, because if you can conflate the two and you can make it seem like one thing happened or didn't happen.
So this conversation continues at the bench.
As I was trying to find these rules, I will tell you, I have read these rules more times than
29 pages.
More times than I can count. And there are rules about calling a senator to be a witness. Essentially to the extent that the senators are required to be in here the entire time. you don't allow witnesses to sit in the court and listen to other testimony ahead of them themselves
Clearly,
testifying.
Angela Paxton has been there every single day.
This entire time as she is required. But the rules state that they can, in fact, be called as witnesses. I just, my printed out version of the rules with my highlights and notes is sitting on my desk. We are in the studio. I'm kicking myself for that.
Here we go. Maybe, well, the mics seem to have just opened. Maybe Lieutenant Governor Dan Patrick is about to tell us what's going on here. Oh, nope. He is now conferring with his legal team, as he has done at different times throughout this process. Keep in mind, Lieutenant Governor Dan Patrick is the presiding officer, but himself not an attorney.
No, and that has really come into question in terms of, I think the most pushback we've been seeing is from Aaron Epley, who almost said, I would
almost stop short of, saying he keeps flip-flopping.
Please look at this. Please look at this piece of, legal.
Well, and suggesting that some of his rulings with regard to sustaining or overturning objections maybe have not been as consistent as she would want.
Yeah, so I think I appreciate that our team, our producers in the newsroom asked me, do you want us to bring you your printed notes? Yes, I do. Yes, I do want you to bring them to me so that I can find this more easily. This particular rule that they're debating right now about whether or not members of the Senate can be called as witnesses and what the order is.
But they're not actually, again, they're not suggesting that they want to call her as a witness. This is all about an affidavit.
Right, but the point being that affidavit would serve as, would certainly serve as a form of testimony in this if they're allowed to look at that and see what they're being said. Oh, thank you to Lauren Pedersen who brought me my notes. I appreciate you.
Let me see.
So we can try to find this exact rule.
I'm just doing a
that they're debating here.
Document is hard to search on.
Oh, and it is incredibly hard to search on.
Again, 29 pages.
Yeah.
It's been a while.
29.
Oh, okay. Examination of witnesses.
But I promise you it's not under there.
Okay.
I've read that one over and over. And that's not necessarily what we're looking for. But Tony, let's talk a little bit about what they want to have, which is
they want to have a
300
statement.
pages of, pictures and.
Yeah, again, this is an important thing. There is a shot of Angela Paxton, by the way. Actually, I'm assuming that's her chief of staff. She has consistently talked to this man throughout this proceeding. I don't exactly know who he is, but I'm assuming certainly it's someone from her office, if not her chief of staff. But you can see whatever this matter, well, not whatever this matter is definitely drawing a lot of input to Lieutenant Governor Dan Patrick concerning whether or not this statement, this affidavit submitted by Angela Paxton, the sworn affidavit attesting to the fact that she and her husband, Ken Paxton, paid for the kitchen remodel. Oh,
Yep.
Here we go.
There we go. They say they're going to take a lunch break, as I have found the rule, Tony. So very excited. So this is under Rule 21, and it's Section D, and it states that no member of the court or the presiding officer of the court may be called or volunteer as a witness unless the evidence to be elicited is relevant material, compelling, and not otherwise provable. So you really have
that's what's being being weighed.
What's being, a party seeking to call a member of the court or the presiding officer as a witness must provide notice as required under Rule 5E. So that's our 24-hour notice rule, unless the testimony is requested during the rebuttal period. But in any, which this is, by the way, this is the rebuttal period. But in any event, must prepare a written proffer of evidence and testimony to be elicited. So one of the things you have to think about, people with clear conflict. Senator Brian Hughes, who is named in one of the articles of impeachment, as well as Senator Angela Paxton, you know, they really wrote, you're going to have to do a lot of work if you want to call them up or if you want testimony from them to be included.
But the confusing part about this is that the rules seemingly speak to, based on my reading, the rules seemingly speak to live testimony. Again, what we're talking about here is an affidavit. And so the rules, as best I can tell, Ashley, again, just it's been a while as well since I've read them, but the rules don't necessarily address the submission of an affidavit, correct?
Correct. However, the point is, the point that the prosecution is making is that this is a statement from her.
Correct.
That she, you know,
and so it should
an
be
affidavit that she would have produced and given
had
to the
she,
defense.
right.
There is no other need for Angela Paxton
to testify.
Give them, well, no other need for her to give them 300 pictures from her phone of, you know, that is solely related to this trial. This
right,
is not
exactly.
things that they didn't do a public information request for the
her
pictures off of her
yeah.
phone. That she gave this to them to help prove their case, and therefore those are her statements. And here's the kicker. Are you ready? At the end of the day, you know who gets to make this decision? It all comes down to Dan Patrick. The presiding officer shall rule on the request to call a member of the court. So it's all up to him anyway.
You know, what's interesting to me about this is that, you know, certainly we have seen some wrinkles along the way, some of which, frankly, the public and we were not even clued in on, that happened behind closed doors. But this feels really substantive, I think. You know, whether, you know, what she has, I am curious about what she has to say about the home, what is in the affidavit. Yes, it feels very meaningful and very substantive. And so as we break for lunch here, I think the big question as we return from lunch in an hour or so is whether or not we are going to see or hear the contents of this affidavit from Angela Paxton, which we're told includes pictures of countertops and other fixtures that they were considering picking out for their home in West Austin. So again, just to recap what has happened this morning, we've had testimony from Drew Wicker, Kim Paxton's body man, who testified to overhearing this conversation in the Paxton home between Ken Paxton and the contractor, whose name is Kevin Wood. From here in Austin, in which someone's name, Nate's name, Kevin Wicker seemed to have assumed or presumed that it was Nate Paul. Whether or not they were going to consult with him about the cost of this, we're talking about a $20,000 effort project.
He talked about the cost of this renovation being $20,000, and that this upgrade of the countertops would put them over the $20,000.
And cabinets, don't forget the cabinets.
And apparently sinks too.
Exactly.
The defense, you know, that
they're wanting to submit.
That this would take it over, and all, of course, related to Article 10, which accuses Attorney General Ken Paxton of engaging in bribery. That Nate Paul paid for that renovation to his kitchen in exchange for legal assistance and special access to the Attorney General's office, which you have heard. Countless witnesses, you know, we're on witness, I believe. Let me check my notes. I don't want to get this wrong. We're on witness number 15, and we've heard countless other witnesses say that the keys to the AG's office were really turned over.
Treated as his concierge law firm to Nate Paul. So we are going to take a lunch break ourselves.
Yes.
It is 12:12. We will be back after the lunch break. We've already been promised a very compelling afternoon of testimony. Again, in case you missed this, Kim Paxton's mistress, Laura Olson, was called to the stand first thing this morning. However, it was determined that she had not been given sufficient notice, a 24-hour notice. Her notice went out at 3:53 yesterday, so we presume that around 3:53 or afterwards, she will be called to the stand.
And not noticed for her because she was there. She was actually walking onto the Senate floor. She had gone through the doors into the chamber, but was called back because each side is, that 24-hour notice is
It's
not
for
only
the other
for the
party.
witness, but it's for the other party to get ready to cross-examine whomever that witness is. And so that was, she's there, or she at least was there.
We have pictures and video of her.
And we're certainly interested to hear what she has to say.
But in the meantime, we hope you have a great lunch, and we will see you after lunch.